this case, Lordship, the sole respondent, he expired. So we are required to file a substitution. Let the matter be listed after filing of the substitution application.
Mr. Deka,
Yes, Lord.
J. Deka, learned counsel for the petitioner, submits that the sole respondent having expired, comma, these LRs are required to be substituted and seek some time for the same. Prayer is allowed. The needful may be done for substituting the LRs of the deceased sole respondent. List the matter after
Filing of the application.
after filing of the application. After vacation.
Obliged, Lord.
May it please your lordship.
Yes,
Lordship,
Mr.
I
Boyd.
beg to mention item number 12, my lord.
12.
Item number 12, my lord.
Okay.
My lord, this is a bail application for cancellation of bail
Okay.
for respondent number 226, representing them, my lord.
Okay, cancellation of bail.
Cancellation of bail, my lord.
It's registered as a bail application.
Bail
Cancellation.
application, my lord. That
Should
is
be
not
IA
my
actually.
lord. Yes, my lord.
Anyway,
My lord, I've taken consent from the other side, and my lord, I also seen that the up-to-date TCR is also be required, my lord. So lordship may call for the up-to-date TCR and fix after the vacation.
you have no problem. You have
He's not physically present, my lord. I've taken consent from the learned counsel.
Mr. Boyd, learned counsel for respond number 2 to 6.
226, my lord.
2 to 6 submits that with the consent of the petitioner side, he is seeking an adjournment on the ground that what do you have to do? You have to file a
The up-to-date TCR would be required, my lord.
seeks an adjournment today and submits that the up-to-date TCR will also be scanned TCR will also be necessary, which may not be available today. Full stop. The prayer is allowed. Full stop. Issue requisition for the up-to-date TCR comprising case there is a charge sheet.
Charge sheeted matter, my lord, trial is going on. Actually, my lord, if lordship reflects, on 3rd of July, the matter is fixed for framing of charge. So along with up-to-date up till 3rd of July, then it will start evidence purpose.
Can TCR comprising case diary, charge sheet, and other relevant documents. It is also submitted that the matter is fixed for framing of charge on 3rd July. Full stop. List after the vacation on reopening we can fix.
My lord, towards the end of July, my lord.
So date, have you discussed the date with them?
My lord, they have said that any date, but they asked me to fix a date, my lord.
After that, 20, let it be on 24th July. That's fine.
Right,
Huh? It's fine.
Keep your page.
Thank you, Lordship. I beg to mention item number 24.
Item 20,
4.
24.
Lordship, CD is not available, so matter of 24. Yes,
24 is.
and Indian production may be continued. 24, my lord, in this case, short sheet submitted.
We can take it up also. We can take it up, the matter as it comes, right? Then take a decision on that. We can call for the case diary. It may be possible to dispose it of also. Just wait. Okay. Yes.
I beg to mention item number 15, Lordship.
15.
15.
Okay.
Lordship, matter may be adjourned for the day.
Scan TCR is available, right? L. Bonik, learned counsel for the petitioner, prays for adjourning the matter today. So the scan TCR is available when? This week or after vacation? He is in custody.
Lordship, and it is on the next week.
Next week is holiday.
Give me a second.
Then Lordship, after vacation.
He's in custody, but will it be fair to do that?
If he wants to fix it after vacation, then
Any day, if any day possible before vacation, Lordship.
Because you have some difficulty today, right? So since he's in custody, I think it's better.
26, then
26. Huh?
But item number 2, it is actually for hearing, my lord. It requires some time, my lord.
Okay.
So may I pray
At the
that
stage of admission, you're seeking disposal at the stage of
Yes.
admission.
with the consent that it may come after, immediately after reopening.
technically taken today, shall it be feasible on your lordship's part, madam?
Because I have some issues in the second half, I have some health issues of my parents. So that is why I'm seeking. So if it takes time, it will be better to fix it after the vacation.
Yes.
What do you say, sir? After the vacation? Mr. Ghosh,
It's on 14th,
Mr. Ghosh and Mr.
14th of the number one. 14th.
Raj Bharabhuya, learned counsels for the petitioner and respondent side respective, mutually seek an accommodation. And also submits that perhaps the matter can be taken up for disposal at the stage of admission, but it might necessitate some hearing. How about admitting it? Should I admit and fix it for hearing?
Then if come hearing, then it may,
If it is admitted by law, then it will be in the
In the-
hearing part. It will take in a initial course long time. Let me put even on the.
We have to do
admission.
something about the hearings also. Because it has to come chronologically.
On 14th,
List on 14/7.
can it be on 16, my lord?
It can be, it's up to you.
16.
16,
16,
I have no problem.
because of course, that no. this is
16.
My
No,
land rights.
there is an interim order till today. my lord.
Interim order stands, right, order dated so and so stands extended till the next date of list.
Interim order in IA, my lord.
In the, there's no IL.
IA has been disposed of. In the IA, there was an
There
interim
was,
order.
okay, it comes, it is with regard to this one. So 16th, right? 16th.
Mother.
May I please illustrate? My lord, I beg to mention item number 8 and 9, 9 and 10, my lord.
9 and 10.
Yes, my lord, with the consent of the other side, my lord.
You are for the petitioner,
Petitioner, my lord.
Mr. Talukdar?
Yes, my lord.
The Talukdar learned counsel for the
Let it be.
petitioner side seeks an accommodation with regard to today and submits that the consent of the other side has been taken, but their names have not been shown. No? I think we can mention that also. They have entered appearance,
Yes.
right? They have entered. appearance.
Vijay Mukherjee, my lord.
The full stop, the prayer is allowed. The names of the counsel, learned counsel for the respondent, I think only one respondent, it seems.
Yes,
For the respondents shall be indicated in the cause list on next and subsequent dates. When do you want it, sir?
my lord, after various.
Is the matter?
My lord, but if interim is there, my lord.
I'll do that, don't worry. Is the matter on 28,
Yes.
28/7, interim order white so and so date stands extended till the next date of listing.
In
9 and 10.
CRPI. Interim in CRPI.
Yes.
CRPI.
Okay, sir. Not in the other one.
No, my lord.
CRPI, 209, that likha hua hai.
All right.
Motion.
Motion edit, item number 48.
May I please, Your Lord? My lord, this is PRS bill application, my lord. FR is page number 9. My lord, the victim is a major lady, 24 years old.
Mhm.
Married.
What is the allegation?
My lord, both of them entered into some physical relation 2-3 times. So this cannot be said that this was happened under the misconception of fact. So the victim is very much consenting party. By this time, schedularly call for I may be protected, my lord.
At this stage, my lord, only CG may be called for, my lord, considering the allegation, my lord. Vernacular is at page 13, my lord.
Victim is a major lady, my lord. So it cannot be said that without the consent of her, it was happened, my lord. So from the affair itself, my lord, she looks like a consenting party to the episode, whatever happened between them. So my lord, kindly, I may be.
This new section must have been given. No?
My lord.
Yes. Heard, Mr. A. Pramanik, listed by P. Kolita, learned counsel. And
It is under section.
P. Botak,
64.
yeah, that's a
64.
new section.
My lord, I
That-
categorically stated para 6, 7 and 8.
Hmm.
Actually, there was love relation between them.
There was no love relation, my lord, only before. আসামি জনে পূৰ্বৰ পৰাই উপৰোক্ত হস্পিটেলত কাম কৰি থকাৰ কথা মনত পৰে
Some
হস্পিটেল
temptation has been given, maybe. Anyway,
Yeah, my lord.
recorded statement. Adults have to be responsible themselves also, anyway. Heard so and so, the petitioner is seeking, I'll record the submission of prosecution also, however. Invoking 482 BNSS, the petitioner is seeking regular anticipatory bail in connection with Jogi Gopa PS case number 62 of 26 under Penso section. Full stop. The FIR dated 14/5/26 has been lost by the alleged victim woman herself, indicating her age as 24 years. The gist of the allegation is that while she was working in a hospital where the accused is a co-employee, he indicated to her about his good relation with the hospital authority, and thereafter committed physical relationship with her. Later, he threatened her not to disclose it to anyone. The learned counsel for the petitioner, drawing attention to para 6, 7,
6, 7.
para 6 and 7 of the bail petition, submits that the alleged victim woman is an adult and a co-employee of the accused, and that they had and that the relationship, if any, was consensual, and denies the allegation of having committed an offense as alleged. Call for the learned counsel prays for interim protection, which is, however, opposed by the learned additional people at this stage. Call for the case diary from the concerned police station. Given my consideration to the prayer for interim, in my considered opinion, petitioner can be given an opportunity to record his statement and his version of events at this stage. In such view of the matter, it is directed that in the interim, in the event of his arrest in connection with this case, he may be allowed to go on bail of rupees 50,000 with one surety of the like amount to the satisfaction of the arresting authority, and subject to the condition that he shall cooperate with the investigation and appear before the IO for examination. Number 2, shall not hamper or tamper with evidence. Number 3, shall not in any manner intimidate or harass or harm the informed. Violation of the bail conditions will entail cancellation of the bail.
Alia.
This is the matter.
On 21/7.
You can give it in the like next week thereafter. 27,
Yes, 27.
27/7.
27/7.
Alia, please.
Yes. Mhm. After some time, you were there?
I'm there. They are in custody, Lordship. POCSO matter.
POCSO matter.
Yes.
Evidence not yet started, my lord, fixed on 29/6/26 for evidence. My lord. Earlier on 3 dates, PW.
Yeah, FIR, your Lordship will find page 18, I'm sorry, page 12. Lord. Here, four persons are named as accused, Lordship, and out of them, Lordship, accused number 3 is declared as CCL, Lordship, that child in conflict with law. And the other three persons before your Lordship.
Allegations are difficult.
Allegations are difficult, but if your Lordship sees the medical report, that completely negates, Lordship. Allegation that 4 persons committed that assault, and if your Lordship perused the medical report at page 34, because on the same day she was examined.
Inducted in history of tying hands.
If 4 persons are involved, some injuries might have been there. And paragraph 37, paragraph 37, Lordship may see final opinion. And whatever is there, they will face the trial, Lordship, and they are in custody since 18/8/2025.
The 164 of the girl was recorded, but she's
Yes,
stated to be a
With the help of my lord.
challenge girl.
deaf and dumb, my lord.
Even-
And along with was the victim at that point of time when the incident occurred, he is also my lord, differently able, his brother, my lord,
Yes, yes.
he was also.
Who was stated to be
Yes,
there,
sir.
right?
Yes, sir. And my lord, regarding medical examination, incident occurred on 16/8/25 around 6 p.m. And medical examination on 18/8/25 at 40 p.m. After
Still,
days.
some bruises are expected, but still, nevertheless. But the allegations also we have to go by that. Anyway,
serious allegation, her statement was also at that initially, my lord.
At the same time, Lordship will see that charges were framed on 27/11/2025. But till that, Lordship prosecution did not produce their vital witness, Lordship.
The next date fixed on 29/6, my lord, for evidence.
charge has been framed, no?
Charges framed on 27 November 2025.
Yes, yes. And charges.
Even after, Lordship, 6,
Well-
7 months, they have not produced, Lordship, that vital.
Evidence has not started.
Initially, her statement could not be done because of
And
the
considering
unavailability
that,
of interpreter, special interpreter.
Considering the period of detention and the medical report, Lordship, I am saying.
Medical reports, my lord, at this point of time.
It's okay, yeah, fair enough. You are seeking bail. Let us see. Statement is there, one
Yes,
sixty.
oh, yes, her statement is there. Record, in the record, 183 DM.
Yeah, record on the answer.
With the help of my lord, interpreter, my lord, her statement was recorded.
It will be necessary. Brothers, 164 also recorded.
Other statement, my lord, I have not. found.
Police statement was there, no? Police statement is there, brothers.
Well, I will have to. Brother's name is my lord Sumon Namasu.
His name is?
Sumon Namasu. Sumit. Not Sumon.
I'm not finding it. Anyway, you have a look. You can have a look. Heard Mr. A. Ahmed, learned counsel for the petitioner, and P. Botakur, learned additional P. Footstep. Invoking 483 BNSS, the two petitioners, accused petitioners, the three accused petitioners herein, who were arrested on 18/8/2025. In connection with Ratabari PS case number 141 of 2025 are seeking regular bail, full stop. The said case was registered on the basis of an FIR dated 18/8/2025 lodged by the father of the alleged, father of the prosecutrix, with the allegation that his daughter is aged 14 years, 10 months and is deaf and dumb. It is that full stop, that comma on 16/8/25, she was going along with his younger son, who is also deficient in hearing, to the house of their uncle, and near the place of near when they reached in front of Aryabhata school, Anipur, the accused persons coming there by an auto rickshaw of accused number 1 pushed out his son from the auto rickshaw, forcefully put his daughter in their auto rickshaw, semicolon, took her to a deserted place and committed gang rape on her, and thereafter left her on a road near his house in an unconscious state. Full stop. It is further alleged that his son informed him about the incident, and after searching, he found his daughter lying unconscious on the road near his house. The accused petitioners were arrested during the investigation. Full stop. The investigation resulted in a charge sheet and subsequently registration of special sessions POCSO case number 71 of 2025, which is at the stage of trial before the learned additional session judge FTC Sribhum. Full stop. The scanned TCR is available. The learned trial court has also submitted a systematic list of dates and status report of the case. And going by the same, it is revealed that on 27/11/2025, charges were framed against the accused persons under provisions of BNS as well as section 6/12 of the POCSO Act. Full stop. And however, it is clear from the subsequent dates that prosecution evidence has not yet started, though case was fixed for the same on some dates. Full stop. Mr. Ahmed, learned counsel, submits that the petitioners deny the allegations and has also drawn my attention to the medical report, which and submits that the said medical report negates the commission of any sexual assault, and it is also bereft of the finding of any bruises, etc., or injuries upon the victim. The learned counsel submits that the petitioners are seeking bail on the ground of length of detention as well as the findings of the medical report. On the other hand, the learned additional people, Mr. Borthakur, opposes the bail and submits that the allegations are serious, very serious, and the prosecutrix is yet to be examined. Full stop. Is T. Parasa, learned amicus, kindly submit your submissions. Sorry, I forgot to.
Lordship, the medical examination was done 2 days after the date of occurrence. And also, Lordship, can peruse page 37.
37? 37, yes, 37 of the petition, right?
Lordship, page 35 of the petition.
Petition.
Lordship, point number 4, it says as victim gave a history of washing clothes and bathing after the incident. That is important to note, your Lordship. Also, Lordship, what needs to be taken into account is that the victim is differently able, or along with, sorry, your Lordship, along with her brother who was present there. The Lordship, considering the fact that the victim was dumb as well as speech impaired and was brutally allegedly gang raped, my submission is to reject the bail at this stage, your Lordship.
কি লিখিলো? Three parasol, I'm a learned amicus curiae appearing for the informants, respond number 2. Also opposes the bail and draws attention to the part of the medical report in which it is stated that the victim gave a history of washing clothes and bathing after the incident. And further submits that the medical examination was done 2 days after the alleged incident. The learned amicus also points out that the victim, apart from being subjected to alleged gang rape, is also a differently able person. Full stop. I perused the relevant materials and considered the submissions. Full stop. The statement of the alleged victim girl was recorded during investigation before learned JMFs. Her statement lends support to the allegations in the FIR. And she has stated about the incident on similar lines. Full stop. I peruse the statement of the auto rickshaw driver. He is also an accused auto rickshaw driver. Auto rickshaw driver as well. Full stop. And the statements of some of the other witnesses. Full stop. Considering the undoubtedly the nature of the allegations are indeed serious, being of gang rape upon a challenged girl who could not hear and speak. First of the prosecution evidence, despite some delay, the prosecution evidence has not started. Therefore, at this stage, it will not be prudent to grant bail to the accused, and accordingly, the bail petition stands rejected. However, the learned trial court is requested to expedite the trial, especially the examination of the prosecutrix, her brother, and other crucial witnesses. Full stop. The bail petition stands dismissed and disposed of.
May I pay out this matter will be taken over after vacation load.
Which one? Next
after
one?
14.
Next one?
14, yes,
Sorry. Okay, this one, no? 14,
14.
after vacation. Which you wish, NDPS. Mr. Amit, learned counsel submits that the matter may be taken up after the vacation. The scan TCR is available. Should we get an updated? No, it's okay. Full stop. Then when the immediately
Right,
upon reopening, you can suggest a date. You have
21, sir.
21.
21,
16 or 17.
17,
17.
17/7.
How like?
Well, in this case, when a TCR was called for, madam.
When the TCR received minor, I have controlled the report minor. Here, 3 witnesses examined minor out of 13 witnesses minor. Here, PW 2 is the victim minor. Lordship may kindly peruse the statement of the PW 2 minor.
Is it a POXO case?
POCSO case,
I
minor.
see.
POCSO.
Oh, sir.
Allegation against his father.
Father, unfortunately.
Lordship may kindly peruse PW 2 minor.
She is examined,
Examined minor.
but whether it will be prudent to grant because he may,
Minor.
are they staying in the same house?
Minor.
He may go back to the same house. That aspect has to be seen.
Minor.
Okay, I pray before lordship, madam, this matter will be taken after vacation, madam, not today.
Is it?
Today, actually, I am also handicapped by the.
Huh?
And my file is not available.
Yes,
madam.
as you
That's
wish,
why I was there after vacation.
As you wish. In
Minor.
any case, it's a difficult
It's a-
situation,
yes, madam,
difficult
that's-
situation, but she has been examined. That's good.
That's why, madam.
Okay, so then let it be. Then let's stop. Same no, I got to Mr. Doctor. We will take up. How about 17?
Fine.
We'll see. On that.
17, 18. Accept.
Wait, please allow.
These are two regular bail applications, my lord.
Yes.
Item 17 and 18 arising out of the same fire. I am
Fire.
appearing in item 17, while London Plan appears in 18, my lord. My lord, in this case, the allegations are under sections 22C, 25 and 29 of the NDPS Act.
Okay.
8.455 kgs of yaba tablets were allegedly found in the possession.
8.5
455 kgs. of-
yaba tablet is a psychotropic substance.
Yes.
What is the commercial?
Commercial
I
quantity,
don't remember.
50 grams. 50 grams. sir.
50 grams,
50 grams. Here 8.455.
8.45?
455 kgs.
Oh, then it will
But
be.
the issue here before your lordship, which your lordship will examine, and that is principally, that is the bail application is founded upon, is the fact that the arrest, my lord, when the arrest was carried out, there was infraction of section 36 of the BNSS. In so much as, my lord, the arrest memo was not attested by any independent witness, my lord. In fact, by any witness. If your lordship in item number 17 will kindly see page number 23, my lord.
Yes.
Page number 20, your lordship has page number 23, my lord.
Mhm.
At page 24, your lordship will see
Mhm.
the signature of the accused person is there and the signature of the arresting officer is there,
Mhm.
but there is no signature of any attesting witness as is required by section 36. my lord.
Mhm.
So now, my lord, as of now, my lord, there have been multiple judgments coming from this
Yeah.
honorable court, my lord,
True.
taking different views, my lord, on whether section 36 is mandatory or
Mm.
directory. So if your lordship permits, my lord, I may be allowed to submit on this
Yes.
aspect as to why it is.
Surely you
mandatory.
guided me.
Well, the fundamental aspect of curtailment of personal liberty, my lord, it flows from Article 21, my lord.
These are meant to be followed,
Right.
not meant to be flouted. These things are meant to be followed when it is given by legislature.
Well, the necessary concomitant of Article 21 is, my lord.
BNSS conduct. Thus, BNSS. CRPC conduct.
My lord will also
Yes.
have CRPC because we will also rely on both.
Regarding the same point, some other matters fixed tomorrow, man. The day after tomorrow.
Yeah, no, that was on a different, there are two kinds of issues actually. One is standalone, suppose only look at it from the point of view of the arrest memo. The arrest memo does not have any signature of attesting witness, whether on its own that will vitiate arrest. The second question which we have fixed is that there is full compliance of 48 and 47, but there is the arrest memo suffers from that deficiency. In that case, what happened? I'd be grateful if you will take the hearing today, a little bit at least. If necessary, we'll keep it part. So you can show me one judgment which has allowed one.
Well, I have brought a compilation, my lord, of major judgments, my lord.
So because we have to see the reasoning.
Well.
Because on principle, then there cannot be conflict of
Well.
coordinatements.
Well.
Then it has to be referred.
So, my lord, the concomitant of necessary concomitant of Article 21 is that, my lord, personal liberty can be curtailed only as per procedure established by law, my lord.
Hmm.
So there must be an established procedure of law under which a person's personal liberty can be curtailed. So, my lord, this law, my lord, can be of two kinds, my lord. It can be, my lord, judge-made law, my lord, in the form of judgments of the constitutional courts, or it may be a statutory law, my lord. So there has to have the curtailment of the personal liberty of the accused must be backed either by a law which has come from the constitutional courts or from the statute. Now, as regards the arrest modalities, my lord, the first judgment, in fact, the quintessential judgment on this is, my lord, D.K. Basu, my lord. But I'm giving a copy of the compilation of all the judgments. D.K. Basu starts from page 1 of my compilation, and your lordship will kindly come to paragraph 35, which your lordship will find at page number 26, my lord.
Marked also.
Yes, my lord. Page number 26, my lord, and paragraph 35, subparagraph 2, my lord.
Yes.
May I read, my lord? That the police officer carrying out the arrest of the arrestee shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one witness who may either be a member of the family of the arrestee or a respectable person of the locality from where the arrest is made. it shall also be countersigned by the arrestee and shall contain the date, time and date of arrest.
Hmm.
So this is the first instance when the Honorable Supreme Court lays down this guideline.
Hmm.
And Honorable Supreme Court says that this flows from Article 21. So arrest memo has to be there, it has to be countersigned by the arrestee, and it has to be attested by either a family member
Hmm.
or, my lord, at least one witness, my lord. So this
Respectable
came,
person of the
society. Now
of-
this came,
of
my
the
lord, in
locality.
1996, my lord.
Hmm.
So thereafter, my lord, this was incorporated in the statute, my lord. Yeah, in the CRPC, my lord, by bringing in Article 41B, my lord. If your lordship will kindly take Article, section 41B,
Blue
my
pencil level also. Blue.
also CRPC, my lord.
Blue. Lila pencil. Lila. Is what below? Yes,
Section 41B, my lord, of the CRPC.
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 CRPC. দিয়া নাই CRPC খন দিয়ক CPC দিলে আমি CRPC anyway I'll follow you, just proceed. Don't stand from them.
No, I'll just read out, my lord.
আছে ভিতৰত আছে silent. Yeah, you read out please.
Section 41B, my lord, this was enacted in, my
I have
lord,
brought some familiarity, you can read.
it came out from the Amendment Act of 2009, my lord,
Hmm.
with effect from 1/11/2010. And 41B, clause B, my lord, it mandates, my lord, that every police officer while making an arrest shall prepare a memorandum of arrest, which shall be, number one, attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made,
Mhm.
countersigned by the person arrested. And clause C says, inform the person arrested
Hmm.
unless the memorandum is attested by a member of his family that he has a right to have a relative of the family
Hmm.
or a friend named by him to be informed of his arrest.
Hmm.
So this was 41B, my lord, which came in
Hmm.
2009 with effect from 2010, my lord.
Hmm.
In fact, the series of sections were 41A, B, C, D all came in by the amendment of 2009
Hmm.
to incorporate the guidelines of DK Basu, my lord. And the corresponding provision, my lord, in the BNSS is section 36, which is, my lord, similarly worded, my lord.
Section 36.
36, similarly worded, my lord. Now, there's another provision which I would like to take your lordship to. That is section 62 of the BNSS, my lord.
Six, 62.
62, my lord.
62.
Arrest to be made strictly according to Sanhita. No arrest shall be made except in accordance with the provisions of this Sanhita or any other law for the time
Hmm.
being in force providing for
Makes it
arrest.
clear.
So, my lord, section 36 and 62 read together,
Hmm.
it lays down the procedure in which the arrest is to be made. Now, your lordship is well aware of the judgment, my lord, of Nazir Ahmed versus King Emperor, my lord, goes back to Privy Council things, my lord. That when the law prescribes a particular mode of doing a thing, but it has to
That's
be
one
done
of the
in
original
that,
judgments on this
Right.
principle, like
Right.
Nazir Ahmed compared.
so it has to be done in that mode only, and all other modes are prohibited, man.
It's Privy Council.
Privy Council, man.
Okay.
So, my lord, here the Sanhita and the erstwhile CRPC gives a very clear mandate as to how the arrest is to be made. So, read with Nazir Ahmed, it would be very clear that it has to be made in that way only and no other way. And the way is that after making the arrest memo will be prepared,
Hmm.
countersigned by the accused arrestee, and it will be attested by a respectable member of the society, of the community, or a family member, my lord. No, my lord, one of the purpose of section 36, or the purpose of this arrest memo, my lord, this is a foundational document, my lord,
Hmm.
about the transparency of the arrest, my
Hmm.
lord. How the arrest was made,
Hmm.
where the arrest was made, and in what circumstances the arrest was made.
Hmm.
This can only be gauged from the arrest memo, my lord. So this remains the foundational document. Apart from that, my lord, at the time of arrest or after arrest,
Hmm.
if your lordship sees, my lord, an accused, an arrested person broadly has to have multiple rights, my lord, but broadly 4 rights, my lord, which all flow from Article 21 and 22, my lord. First, my lord, this arrest obviously has to be made, my lord, in accordance with law. So if it's a bailable offense, if he's arrested, he will be released on bail. If it's an offense punishable up to imprisonment for 7 years, then the conditions of 35(3) comes. So all other parameters of law, my lord, as laid down by the procedure court, my lord, that have to be followed. Now, after this person has been arrested, then he will have to be informed of his grounds of arrest, why he has been arrested. After that, his family members or relatives or nominated persons will also have to be informed of the grounds of arrest. And thereafter, my lord, he has another right that within 24 hours of his arrest, he has to be produced before the nearest magistrate, my lord. So these are, my lord, four essential rights, my lord, which are inviolable, my lord. This cannot be violated, my lord.
And even if he is detained in some kind of a formal manner, the 24 hours should count from them.
From them,
that
that
time.
period. No, my lord, these are watertight compartments, my lord. These are compartments which
Then
do
only
not
it will be
move.
safe.
Yes, my lord.
Tomorrow you can talk of extending the 24 to 30 hours,
Yes.
but it has to be within that stipulated time.
So these have been compartmentalized, my lord, but each has to be individually complied with, my lord. So it cannot be, and that is why the Honorable Supreme Court have time and again pronounced judgments citing that suppose, my lord, a person, he is only informed of his grounds of arrest, but his family members are not informed. His arrest still gets vitiated. Everything has been complied with. He is not produced before a magistrate. Within 24 hours, his arrest gets vitiated, my lord. So these have to be individually complied with, my lord. Now, if there is any infringement, my lord, it violates his, vitiates his arrest and also the consequent detention, my lord.
The law has reasonably crystallized by
Fine,
now,
fine.
actually. Now, if they make mistakes on these things, then, someone would be justified to attribute motives also to the investigating agency.
Well, out of these four rights, my lord, the first one, my lord, is the arrest procedure, my lord. That would be inclusive of this, my lord, preparation of the arrest memo, my lord. Now, well, this takes place at the time of arrest, my lord. When the person is arrested, this arrest memo is to be prepared. It will be countersigned by the arrestee and the attesting witnesses. The other three rights, my lord, informing him about the grounds of his arrest, his family members to be informed with, and his production.
47,
These
48.
47, and my lord, section 58, the 24-hour period. This will come after the arrest. So the arrest memo part, my lord, preparation of the arrest memo part comes at the time of arrest. The other three come after the arrest, my lord. So, my lord, things which are required to be done at the time of arrest, they cannot be done at a subsequent stage, my lord, because a subsequent act will not validate, my lord, an arrest which may otherwise be invalid. So when a particular time has been given for doing a certain thing, like, my lord, a person is to be produced before a magistrate in 24 hours. If he is produced after 36 hours or 48 hours, even if there is a judicial order authorizing his remand, even then his arrest would remain vitiated because the subsequent act will not invalidate the previous act, my lord. Well, what are the reasons for, my lord, this arrest memo attestation, my lord? That is also crucial, my lord, should examine, my lord. First of all, my lord, the arrest memo will stand as a proof of the fact that the accused has actually been arrested as claimed by the police, my lord.
Yes.
Because police action would require, my lord, proof of compliance. But as for instance, my lord, if a seizure is made, my lord, a seizure requires to be attested by two witnesses. Now, say seizure cannot be proved by merely producing and exhibiting the seizure list. It will have to be proved by the examination of the attesting witnesses, my lord. So likewise, my lord, when the arrest memo mandates that it has to be attested by a witness, there is a salutary purpose behind this.
Suppose the arrest is disputed,
Disputed,
then
ma'am.
who will prove?
Because your lordship had dealt with a matter, my lord, the Kiran Singha matter, my lord, where this person was detained at night. Subsequently, he was shown to be arrested at a later point of time. Now, for computing the 24-hour period, as your lordship had pointed out, it is the actual period of custody which is the starting point, my lord.
That
So
was
if
from
the-
the Supreme
yes,
Court.
it was from Supreme Court, my lord. So these are contentious issues which will arise. my
As
lord.
I said, you can quarrel with the 24 hours, that 24 hours is not sufficient.
Right.
It should be 30 hours today. But in my opinion, there should not be quarrel with the proposition that the moment a person is detained in a reasonably formal manner, it has to be from there.
So when these contentious issues arise as to when the actual arrest was made, in that case, my lord, this arrest memo stands as a proof of that fact, and the attesting witness would be able to establish whether the arrest was actually made at that time when claimed by the police. If the police claimed that he was arrested at afternoon and it was found that the person was detained in the morning, if these issues arise, then, my lord, this is the way to solve this issue, my lord. Suppose there may be a case, my lord, a woman is arrested after sunset, my lord, which is otherwise not permissible except with the order of a magistrate. So this arrest memo, the arrest memo says that no, the person was arrested during daytime, and it is contained that she was arrested in the night. So all of these things, my lord, would require to be proved, my lord. And that can only be done but through this attesting witness. And that is one of the reasons, my lord, there is this arrest, because this personal liberty, my lord, gets curtailed the moment he is arrested. So it, in a way, my lord, it's the starting point of the person's incarceration or subsequent detention, my lord. So here this point becomes of vital significance, my lord. And my lord will notice in 36 as well as in 41B, my lord, there is no exception which has been carved out for this attestation, my lord. That unless otherwise provided or in exceptional circumstances, this attestation may not be there. 41B and 36, they do not contain any exceptions, my lord.
DK Basu is clear also.
Clear on this point, my lord.
Because these compliances should be in a way in black and white, because if they are ifs and buts,
Yes.
it will lead to all kinds of confusions, and then you'll keep interpreting whether it has been complied, to what extent it has been complied. Then you will talk about prejudice
Yes, ma'am.
also.
Because
So best, the learning would be best
Yes.
for the investigating officers if it is clear. Absolutely.
because in NDPS cases, especially, my lord, this timing also becomes very important for the purpose of sections 41 and 42, my lord. And the seizure invariably gets intertwined with the arrest, my lord, because they are arrested at the same time and the seizure is also made at the same
Right.
time.
Mm.
So the timing in which the person gets arrested becomes especially important in NDPS cases, my lord. And even in this case, if your lordship will see, the arrest memo shows the time of arrest as 1:30 PM, my lord. Whereas if the FIR is seen, my lord, these persons were caught and taken to the police station at night. So even in this particular case, in the peculiarity of this case also, this issue arises, my lord. What was the actual time?
There's
of
actually
arrest?
there is a gray area in the sense that today we are talking about of course the insistence on the time period of 24 hours is justified. Today it is 24 hours. I said you can quarrel with that whether it should be 24 or 27 or whatever, but it is 24 hours. You are required to comply with that, and from formal detention. Okay, that is necessary. On the other hand, we are also talking about following, not arresting a person recklessly at the drop of a hat. And even if you decide to arrest the person, you must follow the procedure of arrest memos for notice to him, notice to his family. And in cases like NDPS and all that, the seizures and all, it take their own time. So we have to, provide for that also. But at the same time, as I said, I mean, both have to be done actually. That is the challenge before the police official or the law investigating person, that he has to maintain that time period as well as follow this. So the challenge for him is to, because if he does not follow the arrest procedures, hastily goes, then there may be defect in the seizures. At the same time, if he follows everything and gets delayed, then of course, then also it will be defective. So that is the challenge. For the moment, he has to meet the challenge. Tomorrow, if the law gives some more flexibility, suppose for certain kind of offenses, suppose it is increased till 30 hours, suppose, then maybe. But today, there is no other option but to say that he has to meet both the challenges, follow the arrest procedure properly, as well as follow the time.
Ultimately, at any court, within
To that extent, he has to be smart to the situation. No other option. Anyway, please proceed.
So, madam, that is why this section 30, this is an essential protective procedure, madam, which has been laid down in 41B or 36, my lord. Because this stands as the only statutory safeguard, my lord, against possible, my lord, anti-timing of the arrest, my lord.
Yeah.
Or possibly, my lord, manipulation of the records also. Because these things can never be ruled out, my lord. So this document remains as a proof that this arrest was made at this particular time and in these circumstances, my lord. And this, my lord, is irrespective of the gravity of the offense, my lord.
That's okay.
So it cannot be that just because an offense is serious or grievous, it would imply that these statutory requirements can be waived, my lord. The judicial dicta in DK Basu, the statute in this case is, my lord, very clear, my lord. There is no dispute on that aspect, my lord. So one aspect, my lord, which has come up, will produce the judgments, my lord,
But
is this dichotomy between 36 and, my lord, section 48, whether a communication of the written grounds of arrest to a family member in terms of section 48 of the BNSS would suffice the ends of section 36, 1B, my lord. So, my lord,
on the face of it, it should be no.
No.
Because, we have to decide that issue, but because they are not meant to be substitute of one another. the arrest memo cannot be a substitute because they have their own different purpose. Otherwise, it could have been one section that, you give. And as I have understood, in my humble opinion, the more clearly you lay down these things, the ultimately, initially there may be mistakes, but ultimately it will be easier for everyone.
Yes.
But now question is, Mr. Nawaz, that if there are, on this point, as I said, on the principle that whether this will be, if there are conflicting decisions,
No, I'll
then
place my lordship will
as a
examine
single,
this
as a single judge, what do we do? Do we refer?
Conflicting this.
No, I'll place the
If
judgment.
it is referred, then that will take its own time. Then what happens to the bail then? The person will be in detention.
But I'll try to satisfy your lordship that this can be decided by your lordship here itself.
Please proceed.
So 36B, these are both mandatory provisions, my lord, 36B as well as my lord, section 48. Now, the wording, my lord, is very important in 36 as to why the proposition which has been contended by the state, my lord, while going on that this is a substitute, but this is not a correct proposition. If your lordship sees 36 for a moment again, my lord. Every lordship has it, my lord. Every police officer while making an arrest shall, A is, my lord, that is not connected to this case. B, prepare a memorandum of arrest which shall be attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made, countersigned by the person arrested, and inform the person arrested unless the memorandum is attested by a member of his family that he has a right to have a relative or a friend or any other person named by him be informed of his grounds of arrest. Now, this contention that 48 will suffice, my lord. In fact, if your lordship says section 36 is the other way around, my lord. First thing which is done in terms of 36B is that the arresting officer will prepare a memorandum of arrest. He will get it attested by a witness who is either a member of the family or a respectable member. Now, C says that if inform the person arrested unless the memorandum is attested by a family member of the family. So first, preparation of the arrest memo. If it is signed by a member of the family, then it's not an issue. If it is not signed by a member of the family, then he will be informed that he has a right to inform his family members that they will be informed of the grounds of arrest. So first thing is the preparation of the arrest memo and the attestation. So if the attestation is done by a family member, then not done by a family member, then the question of 48 will come in mind. So it's not the other way around as has been contended, my lord, in all the other cases, my lord.
If it is not done by a family member, then
inform the family members of the grounds of his arrest. So this chronology has been altered, my lord. Correct chronology is arrest, memorandum of arrest first, then the notice, my lord. Because this also makes sense in a way, because the arrest memo is prepared at the time of arrest, notice comes after the arrest, my lord.
immediately after.
Immediately after. If there may be situations, my lord, a person is arrested, a family member may not be there. So they have put in this exception that it may be a respectable member of the society also. As far as 48 is concerned, my lord, your lordship has also addressed this issue, my lord. A person from outside the state is arrested here. So immediate service on the family members in terms of 48 may not be possible. So it can be sent electronically also, but they'll have to take an endorsement in the case diary. But if your lordship will see that this issue as to whether this is a substitute or not, my lord. Section 48 does not in any way stand as a substitute for section 36, my lord. Suppose, my lord, the electronic notice is sent to a family member who is outside the state. It will take its own due course of time. Suppose they send it to WD messages, my lord. It will take its own due course of time. But this arrest memo would require to be arrested at the very stage of arrest, my lord. It cannot be kept pending for several hours waiting for the arrest notice to get served, my lord. So, my lord, this argument, in my respectful submission, that section 36C can be brought in to negate 36B1, my lord, is at best a subterfuge, my lord.
Or say it appeals to me also, my lord. This line of thinking.
Also, my lord, if 36C was intended to be a substitute to 36B, my lord, then the legislature would have brought in it as a proviso to 36B, my lord. In many cases, when provision is there, if there is an exception, that is brought in by the way of a proviso. But the very fact that these two are there, and my lord, there is a conjunction between them, my lord. B1 and C, my lord. And, my lord. So this is not meant to be a proviso. The 36C will some way, in a way, come in the way of, in place of 36B. Now, one more thing, my lord, I would like to address this honorable court as to why this cannot be a substitute. If your lordship will kindly have the CRPC for a moment.
CRPC.
CRPC.
Yeah.
Your lordship will kindly take 50A, my lord. 50A CRPC, which is the corresponding provision of 48 BNSS, my lord. Your lordship will see this came in 2006, my lord, by way of the Amendment Act of 2005, my lord, with effect from 23/6/2006, my lord.
Right. Only in 2006.
2006. 58. 58 and 48. And your lordship will see 41B for a moment, which is the equivalent of 36, my lord.
41 B.
B.
Uh,
So this came in, my lord, with effect from 1/11/2010 and was brought in by the amendment of 2009, my lord. So, my lord, if section 50
Incorporating the what was laid down in DK Basu.
all of the judgment, my lord, all of the provisions from 41A onwards, my lord. So, my lord, if 50A was to be a substitute for section 41B, then there was no need for the legislature to bring in it by way of a separate amendment 4 years later, my lord. So when your lordship will examine the legislative intent behind this provision, your lordship will also examine the timelines of the amendment next, my lord. Timelines when the statute was amended, my lord. 50A comes in 2006, 41B comes in 2010. So 50A was never meant to be a substitute for 41B. Otherwise, there was no need. This is the superfluous exercise by the legislature by bringing in 41B because 50A was already there. And this was, and DK Basu was before the legislature because DK Basu came in 96.
Yes.
This came in after 10 years. So DK Basu was there for 10 years and yet the legislature did not bring 41B in 2006, my lord. So this very fact, my lord, that a separate provision has been added regarding the attestation of the arrest memo, my lord. This is very, the legislative intent becomes very clear, my lord. My lord, in view of this submission, now I place the judgment, my lord. My submission before the honorable court is that, my lord, here the very foundational document of arrest, my lord, that stands vitiated because this goes against the statute. It goes against the judicial dicta, my lord. So this makes the arrest itself, my lord, illegal, and this becomes an infraction of Article 21, and this makes the accused person entitled to bail. And this is irrespective of the rigors of Section 37, because here the very foundation of the arrest gets vitiated. Now the judgments which your lordship will kindly see. First, your lordship will kindly come to page 65, my lord. EA 3804. EA 3804 of 25. Well, this is an order from this honorable court dated 17/12/2025. The lordship will kindly come to para 12, page 69, madam.
Okay.
May I read, madam? Para 12. What is discernible from the aforesaid two sections is that there is a mandate provided by the aforesaid section of 36 that the arrest memo has to be signed by a witness. Either he is a member of the family of the arrested person or a respectable member where the arrest is made. Section 62 provides that no arrest shall be made except in accordance with the provisions of BNSS or any other law for the time being in force providing for arrest. Therefore, any arrest that has been made is mandatorily has to comply with the provisions and procedure of arrest while making such arrest. Non-compliance of such provisions will be in violation of the mandatory provisions, which will in turn make such arrest illegal. Once an arrest becomes illegal, the arrested person shall have an unfettered right to be set at liberty, that is to be released on bail. Though Section 37 of the NDPS Act provides for certain conditions to be fulfilled before granting bail of an arrested person, in case of seizure of commercial quantity, the same will be applicable only when the arrest is itself not illegal. However, if any arrest is made in violation of the mandatory provisions as laid down in BNSS 2023, then the same goes to the root of the matter and the initial arrest becomes illegal. In the instant case, it is seen that the arrest memo does not contain any signature or attestation of any person, neither of a member of the family of the arrested person or of any respectable member of the locality where the arrest was made. This clearly violates the mandates of section 36 and 62 of the BNSS.
Yes,
Yes, ma'am. So next, your lordship will kindly come to page 72.
just. a minute. Yes,
This is my lord bail application 3650 of 2025. Your lordship will kindly come to page 79. The relevant portion starts from para 18. My lord. This your lordship will also note the date, my lord. This is dated 20th of January 2020.
yes,
Para 18. Section 36B of the BNSS provides that the police officer, while making arrest, shall prepare a memorandum of arrest which shall be attested by at least one witness who is a member of the family of person arrested or a respectable member of the locality where the arrest is made, countersigned by the person arrested. The question is as to whether the aforesaid provision is a mandatory provision or a directory provision. The submission of the learned additional public prosecutor that since, as per section 36C of BNSS 2023, the arresting police officer is required to inform the person arrested that he has a right to have a relative or a friend or other person named by him to be informed of his arrest in case the memorandum is not attested by his family members, itself shows that the requirement of attestation by one of the family members in the memorandum of arrest is not mandatory, is not a convincing submission and hence not acceptable to this court. On a careful perusal of 36C of the BNSS 2023 reveals that the said clause would become operational only if the memorandum of arrest is not attested by one of the family members of the person arrested. However, as per 36B1 of the BNSS, apart from family members of the person arrested, any other respectable member of locality where the arrest is made may also attest the memorandum of arrest. Only because of the fact that section 36 BNSS mandates
right.
the arresting police officer to inform the arrested person regarding his right to have a relative or friend or other person named by him of his arrest does not dilute the requirement of attestation of the memorandum of arrest by at least one witness as provided in section 36B1 of the BNSS. Now, a division bench judgment of the Calcutta High Court was relied, my lord. That has also been addressed, my lord. As regards the observation of the division bench of the High Court of Kolkata in the case of Hero Sarkar versus Union of India, that as section 37 of the NDPS Act was not in issue before the apex court when the judgment of D.K. Basu was delivered, and as section 37 of the NDPS Act starts with a non-obstante clause giving overriding effect to the provisions of the said section over other provisions of the Code of Criminal Procedure, the view of the Kolkata High Court that even if an arrest is made without complying with the provisions of section 41 of B of the CRPC, it would not per se override the embargo of section 37 of the NDPS Act is not very convincing, and this court is unable to persuade itself with the reasoning and logic given by the Kolkata High Court. With due regard to the view taken by the Kolkata High Court in the case of Hero Sarkar, this court begs to differ with the reasoning of the same court that merely because of the fact that section 37 of the NDPS Act starts with a non-obstante clause, it would override all provisions of the Code of Criminal Procedure. There are certain provisions in BNSS 2023 which even the non-obstante clause of 37 of the NDPS Act cannot override, namely those provisions which emanate from Part 3 of the Constitution of India and whose infringement would amount to violation of the fundamental rights guaranteed by the Constitution of India. The apex court, in the case of D.K. Basu, Supra has observed that the guidelines issued by it in the state judgment, including guideline number 2, which correspond to the requirement of preparing an arrest memo and obtaining signature of at least one witness thereupon, apart from the same being countersigned by the arrestee, flows from, this is important, Article 21 and 22 of the Constitution and needs to be strictly followed. The aforesaid observation of the apex court in G.K. Basu's case leaves no room for doubt that the aforesaid procedural requirement, as contained in 36B1 of the BNSS 2023, has emanated from Article 21 of the Constitution of India and are mandatory in nature. This court is of the view that Section 36 and Section 62 of the BNSS are only statutory exposition of the constitutional norm provided under Article 21 of the Constitution of India. Hence, same cannot be overridden merely because of the presence of a non-obstante clause in Section 37 of the NDPS Act. Section 62 of BNSS 2023 casts a duty upon the arresting authorities to make the arrest strictly according to BNSS. It lays down that no arrest shall be made except in accordance with the provisions of BNSS or any other law for the time being in force providing for arrest. The arresting authorities, while making an arrest in a case involving an offence under the NDPS Act, cannot defy the mandatory duty cast on them by the aforesaid procedure. This is not merely an ornamental provision in BNSS 2023. It is there to be followed by the arresting authorities. The rigors of Section 37 of the NDPS Act would be applicable to a case only if the mandatory procedural requirement of Section 36 of the BNSS is followed. In a case involving serious nature of the offense, which is involved in the instant case, the arresting authority has to be more cautious to ensure that all the mandatory procedural requirements of arrest are followed. This is what was pointed out by your lordship. Followed, so that the accused does not get the benefit of failure on the part of the arresting officer to comply with the mandatory procedural requirement as provided under BNSS 2023, as well as the Constitution of India. Since the procedural requirement of attestation of the arrest memo by at least one independent witness has emanated from Article 21 of the Constitution of India, the same is mandatory in nature and the same cannot be overridden by another statutory provision like that of Section 37 of the NDPS Act. Now, your lordship will kindly come to page 85. I'll also produce the judgments which are against us. 85, my lord will kindly come to para 6, page 87. 6 and 7. Anwar Rashid.
6 and 7.
Rashid Chaudhary.
Para 6
No,
and 7.
Para 6, my lord. This court has considered the rival submission. Lordship has it.
Yes.
This court has considered the rival submissions and is of the opinion that the fundamental rights are paramount under the Constitution of India, where Article 21 provides that no person shall be deprived of his life or personal liberty, except according to the procedure established by law. And Article 21 of the Constitution of India further provides for protection of a person against arbitrary arrest and detention, including the right to be informed of the grounds of arrest, and that a citizen should not be detained without informing him of such grounds. It is not in dispute that in case of NDPS Act, also the provisions of arrest of a person as laid down in the PNSS 2023 must be complied with. For the purpose of that part, I'm skipping my lord because the statute has been introduced. Last my lord from the bottom, my lord, fourth line. It is apparent from a conjoint reading of the aforesaid two provisions that memorandum of arrest is a necessary document that serves as confirmation that the individual in question was arrested under certain circumstances. In other words, it creates a point of reference to determine the circumstance under which a citizen was detained/arrested. Therefore, it must provide the particulars that are specific to the arrest. A minimum of one witness is required, who should be a member of the accused person's family, and where a family member is unavailable, a respectable individual of the locality in which the arrest is made has to be called upon to testify as a witness. The arrested person is required to countersign the arrest memo himself. Section 62 provides that no arrest shall be made except in accordance with the provisions of the BNSS or any other law for the time being in force providing for arrest. Therefore, non-compliance with such provisions at the time of arrest is to be considered a violation of the mandatory provisions, which would render the arrest illegal. And once the arrest is rendered illegal, the arrest person shall have an unfettered right to have the arrest and detention to be set at normally. Now, my lord, page 92. Here, my lord,
92.
92, my lord. This BA, my lord, 436 of 2026. This is the Honorable Justice Sushmita Fukan found, my lord, dated 15/5/2026.
Yes.
Lordship will find the relevant para, my lord, para 5, my lord. Starts from 5, my lord. Section 36 is reproduced, my lord. There's also the issue of 48, my lord. Then paragraph 7, my lord. I'll also rely on this division bench judgment, my lord. The lordship was also a part of that bench, my lord.
No, not this one.
No.
Mate.
Mati, my lord. Citation, this is criminal appeal 433 of 2020.
No.
Criminal appeal. Okay. Criminal appeal for 433 of 2025.
What's anyway?
So here, my lord, the finding, effective finding, your lordship will find at page 9. I have considered the submissions at the bar with circumspection. I have also scrutinized Annexure 3 series at page 2023, which are the notice under section 48 of the PNSS and arrest memo under section 36 of the PNSS respectively. The investigating officer has indeed not affixed a signature on the arrest memo. Although notice was issued to the wife of the petitioner through WT message, there is no information of service of notice to the petitioner's relative or any acknowledgement supporting that any of the petitioner's family members has received the notice. Thus, the petitioner's right to personal liberty, as held by the Honorable Supreme Court in Bihan Kumar and other reported in so and so, has been curtailed. Here, my lord, this Mate's case was also relied upon, my lord. So I'll come to that also. Next, my lord, we'll kindly come to page 97. My lord. This is a judgment by your lordship, my lord. Okay. Your lordship will find para 10, my lord, page 99.
Para 10.
Para 10, page 99. Before proceeding further, section 36 BNSS may be reproduced here in below. that's para 11, my lord. Thus, it is clearly indicated that the memorandum of arrest has to be attested by at least one witness. These requirements also flow from the constitutional provisions pertaining to liberty incorporated inter alia in Articles 21 and 22 of the Constitution of India, as has been held in DK Basu, para 38, which is reproduced below. So, Lordship has also relied on para 38 from DK Basu. Next, para 12, my lord. Consequently, despite the serious nature of the offences alleged, applicability of section 37 per se, the notices under 47 48 also being found in order due to the infirmity in the notice under section 36B BNSS and its linkage with constitutional provisions as mandated in DK Basu Supra, I am of the considered view that like in the order passed in so bail is also required to be given in case, my lords. Now, my lord, two more judgments, my lord, in favor, my lord. One is page 102, my lord.
On this point, this court has already expressed its view.
My lord.
On this interplay, anyway,
Page 102, man.
102.
102, man. This is a bail order, man, again.
Okay.
Bail application 1199 of 2026, dated 25/5/2026. Relevant portion, man, page 105, starts from para 10. On perusal of the TCR, it is seen that the arrest memo under section 36 of the BNSS has been prepared by the police authority. However, no attestation signature was obtained from any of the family members of the accused applicant or any respectable member of the locality as required under section 36 of the BNSS. It is seen that the arrest memo has been countersigned by the arrested accused applicant and the arresting officer concerned. It is also seen that the notice under 48 has been issued to one so and so at the time of arrest of the accused applicant. Now the question arises as to whether issuance of a notice under section 48 of the BNSS at the time of arrest of an accused person shall suffice the mandates of section 36 of the provisions of the BNSS, though there is no countersign or attestation by any witness or any family member of the accused person. In consideration of the aforesaid issue, it may be relevant herein to refer to the principles laid down by the Honorable Supreme Court in DK Basu, wherein the Honorable Supreme Court in para 35 has, so para 35 has been reproduced, madam. So, paragraph 13, my lord, page 107. From the above, it is clear that the Honorable Supreme Court has directed that while arresting a person, at the time of his arrest, an arrest memo is required to be prepared. Subparagraph 2 of para 35 provides that an arrest memo shall be attested by at least one witness who may be either a member of the family of the arrestee or a respectable member of the locality from where the arrest is made. It shall also be countersigned by the arrestee and shall contain the time and date of arrest. Subpara 3 of para 35 provides that a person who has been arrested or detained and is being held in custody in a police station or interrogation center or other lockup shall be entitled to have one friend or relative or other person known to him or having interest in his welfare being informed as soon as practicable that he has been arrested and is being detained at the particular place unless the attesting witness of the memo of arrest is himself such a friend or a relative of the arrestee. It is also seen that the Honorable Supreme Court has not provided for any exception in subparagraph 2 about the requirement of attestation by at least one witness who may be either a family of the arrestee or a respectable member of the locality from the arrestee's name. But one submission in the middle of this, my lord. Irrespective of the fact, my lord, that there are other views on this aspect, my lord, this one point is clear that this has flown from the Honorable Supreme Court. Supreme Court has mandated this and the Supreme Court has not given any exception, my lord. So this finding of the Honorable Supreme Court subsequently incorporated in the statute is still binding on, my lord, all the other courts, my lord. So this has to be followed, my lord, irrespective of a difference of opinion which may be there, my lord. It may be worthwhile to refer to the observations of the Honorable Supreme Court in paras 37, 38, and 39. The 38, my lord, that 37 and 38 have all been reiterated again, my lord. Then para 15, my lord. In view of the aforesaid directions of the case of DK Basu, certain amendments have been carried out in the Code of Criminal Procedure 1973 with the inclusions of 41A, B, C, and D by the Act of 2009 with effect from 41B lays down the procedure of arrest and duty of the officer making the arrest. After coming into effect of BNSS 2023, Section 41B has been retained in the BNSS as Section 36. One of the same has been reiterated again, my lord, and then final finding, my lord, I am giving it paragraph 25, my lord. The other part is, my lord, repeated, my lord.
Yeah.
Therefore, a combined reading of the aforesaid sections of 36, 48, and 62 makes it clear that while arresting an accused person, the provisions of 36 as well as section 48 have to be independently complied with. There is no exception which has been carved out from section 36, providing that in the event of compliance of section 48, the requirement of attestation of
Answered
at least
already.
one witness,
Mm.
which is who is a family member of the arrested
Mm.
person or a respected member of the locality where the arrest is being made is exempted. Therefore, statutory provisions of section 56 of the BNSS cannot be said to be negated by compliance of the provisions of section 48 of the BNSS. No matter, I'll come to the judgments which have taken the other view, my lord. Your lordship will kindly come to page 132, my lord. This is my lord bail application number 887 of 2026 and dated 23/4/2026. Here the relevant portion your lordship will find at page 136, my lord, para 8. Para 8, my lord, section 36 is quoted. Para 9, section 62 is quoted. Now para 10 also.
There are 10.
Para 10.
Ten to 9. Okay. Yes, please, you can proceed.
Yes. A close perusal of the aforesaid provision of section 36 of the BNSS shows that while clause B, one of the Roman of section 36 provides that the memorandum of arrest shall be attested by at least one witness who is a member of the family of the arrested person or a respectable member of the locality where the arrest is made. Clause C provides that the arrestee must be informed that he has a right to have a relative or a friend or any other person named by him to be informed of his arrest. But such requirement will cease to operate if the memorandum of arrest is attested by a member of his family. In other words, a combined reading of the aforesaid two clauses would show that the requirement of attestation by a member of the family of the arrestee or a respectable member of the locality where the arrest is made is diluted by clause C of section 36 by requiring that the arrestee must be informed that he has a right to have a relative or a friend or any other person named by him to be informed of his arrest, in which case the attestation of the memorandum of arrest by at least one witness as described above is not mandatory. This requirement mandated by clause C finds reflection in section 48 BNSS, which relates to informing the family members, friends, nominated persons, or person nominated by the arrestee to be informed of the grounds of arrest, which is quoted herein below. Para 12, my lord. The purpose of the arrest memo under section 36 BNSS is that it is the formal record of the deprivation of the liberty of the arrestee, and its primary purpose is to provide legal accountability of the arrestee. Therefore, preparation of the memorandum of arrest mentioning the date, time, place of arrest, as well as the place where the petitioner is being detained are all mandatory requirements of law. The necessity of taking the signatures of the witnesses of the kind mentioned in section 36 on the arrest memo is obviously an act of attestation of the particulars mentioned in the memo of arrest. That being the position of law, if the said particulars as available in the arrest memo with regard to date, time, and place of arrest, etc., are communicated to the family members, friends, nominated person by way of a notice under section 48, the purpose is served. In the instant case, there is no dispute that the notice under section 48 BNSS has been duly served upon the wife of the arrestee, mentioning the particulars of the arrestee and also mentioning about the date and time of arrest, as well as the place where he was being held. It is so and so place. But clause C of section 36 BNSS requires is that if the arrest memo is not signed, attested by a member of his family, then he is to be informed that he has a right to have a relative or a friend or any other person named by him to be informed of his arrest. That requirement stands duly complied as the arresting authority has itself.
That means
informed the-
this interpretation says that a 48 notice would be equal to a signature of a relative or a friend on the arrest memo.
Yes, then the subsequent act will somehow, my lord, validate.
It will be
the
equal
earlier-
to a independent witness is different.
Yes.
You know, a family member, either family member or independent witness.
Independent.
48 notice will be equivalent to, will be equal to a signature
On
of
the-
a family member on the arrest memo.
As per the judge. So, my lord, one of the things which lordship will see the entire.
This is
judgment,
the
my lord.
interpretation.
The earlier judgments on this point of law, which I have placed before this honorable court, my lord, but these judgments were not placed before the honorable court, my lord. Because the only judgment which was cited was DK Basu. But the very fact that this honorable court had already formed an opinion that section 36 and section 48 are two distinct provisions. And one compliance of one does not necessarily mean that the other is not required to be compliant. Those were not placed before the honorable court. My lord. Now there is another judgment where again a different view has been taken. That is, my lord, at page 140, my lord. And the relevant portion, my lord, starts from 141 itself.
The reverse may not be true. The suppose the family member is signed on the arrest memo.
Yes.
Will it substitute for a notice on the 40? That will not.
That will be different.
That will not,
That
because
will
the
not
purpose
be
is
correct.
different.
Purpose is different.
The 30
These are
arrest memo is about the factum of arrest,
arrest.
and the grounds of arrest is to inform the person why he has been arrested, and 48 notice is even more important than 14 because to prepare the defense.
Because that is what was in the concurring judgment of my lord Vihan Kumar. That reasoning was given that the person goes to jail is the family members who oppose his remand or who come for bail, my lord. So they need to.
They have to show it to the lawyer.
Yes. Now page, my lord, 141 starts, my lord.
On 41.
141, paragraph 2.
Para?
Para 2, my lord, DK Basu is cited, my lord.
Okay, para?
And then para 4, my lord, I'll start, my lord. I find force, my lord, have it.
Para 4.
Para.
Anyways,
I find force in the argument submitted by the learned additional public prosecutor. The arrest memo marked as annexure 4 clearly reflects that the petitioner was arrested on 22/12/2025 and his signature has been taken. And as per section 36 of the BNSS, there is no ambiguity that notice has been served on the person arrested. The notice under section 36 of the BNSS is marked as annexure 4 of the petition. Then below section 36 is quoted. Then para 5 below. This implies that the petitioner has to be informed unless the memorandum as per 36B is attested by a member of his family that he has a right to have a relative or friend or any other person named by him to be informed of his arrest. The petitioner was thus informed and his signature was taken on the memorandum of arrest under section 36. It is also pertinent to mention at this juncture the requirements of section 36 flow from article 21 and 22 of the Constitution of India, and as held in DK Basu, an article is quickly followed. And DK Basu is again reiterated, then para 8. In this case, the arrest memo marked as annexure 4 and the notice under section 48 of the BNSS marked as annexure 3 clearly revealed that the petitioner was arrested at so-and-so time, on so-and-so date at so-and-so time, and a member of his family was also informed about his arrest and grounds of arrest were communicated to him on the same day, that is on 22/12/2025. Thus, despite the absence of the signature of any of the relatives of the petitioner on the arrest memo, it can be safely held that the petitioner's family member was informed about his arrest in connection with this case on the same day within 12 hours. Thus, there has been no violation of the right of personal liberty as the petitioner's family members have already been informed. The petitioner's arrest and the grounds of arrest have been communicated to a member of his family.
Okay.
Then the different judgments of this honorable court were placed before this honorable court, and now
This judgment took a contrary view? No.
contrary view.
Contrary view.
Contrary view.
It's contrary.
Yes, my lord, para 19 is the final finding.
Go ahead.
In view of the foregoing discussions, it is held that the right to personal liberty of the present petitioner has not been curtailed. It is held that a family member of the petitioner was informed and the notice was served to his relative under section 48 of the BNSS on the same day when the petitioner was arrested and the arrest memo was prepared. The petitioner's signature has been taken down in the arrest memo. The petitioner was also communicated regarding his grounds of arrest. Thereby, there appears to be no justified ground to grant bail to the petitioner at this stage of investigation. The petitioner's right to liberty has not been infringed. Investigation is still under progress and the investigation may be adversely affected. That part is on merits only. So here the view is that because a family member was informed, notice was served on
This
the
is
48th.
the other view.
Other view.
Mm.
Another view, my lord, which is different view, my lord, that is, my lord, at page 155, my lord.
This is a contrary view again.
Contrary view, my lord. Here, my lord will kindly come to page 159, para 12, my lord. Para 11, my lord. Start with para 11. The earlier bail application of the present to petitioners was rejected by the order written so and so with the observation that there is sufficient compliance of 47 and 48 of the BNSS. And in the notice issued to the present petitioners under 47 and 48 of the BNSS, the ground of arrest was specifically mentioned, and it was elaborately stated as to why they have been arrested in connection with this case. However, the present petition has been filed solely on the ground of non-compliance of section 36B of the BNSS corresponding to section 41B of CRPC. As at the time of issuing the arrest memo, the signature of the family members of the accused person was not obtained by the IO, which violates the provisions of section 36B of the BNSS. In the same time, it is also the case of the petitioners that every arrest has to be in accordance with the Sanhita under section 62. It is a fact that while issuing the arrest memo under section 36 of the BNSS, every detail of arrest has been mentioned. However, no signature is obtained from the family members or relatives of the accused petitioner. But it is seen from the record as well as the bail order passed earlier that there is sufficient compliance of sections 47 and 48 of the BNSS, and it is seen that the accused persons were well aware of their grounds of arrest, and their family members were also accordingly intimated through notice under section 48 of the BNSS. Thus, it is not a case that any prejudice is caused to the present petitioners only for non-compliance of 36B when there is sufficient compliance of section 47 and 48 of the BNSS, and the family members or relatives of the accused persons were also intimated regarding the grounds of arrest of the petitioners. That apart, it is also seen in the arrest memo as well as in the notices under 47 of the BNSS. The signature of the present petitioners were obtained intimating the petitioners regarding the ground of arrest. Then Sri Darshan was cited, my lord. So herein, my lord, the element of prejudice was brought in. That because he was aware, notices were there, signatures were there, so no prejudice was caused, my lord. And the last
Case for
judgment,
prejudice involves some subjectivity.
No.
So that is the problem.
the last judgment, para 167,
167.
167.
This is a contrary view again. Contrary view.
Contrary views. Here, the relevant portion your lordship will find at page 179.
179.
Yeah, 1231 of it.
One.
My para page 170, man.
No, this is a new judgment.
Oh.
It's BS 3780.
Yes, no, my lord. BA, my lord, 1231.
Okay.
Starts with one para 1.
3780 is not a contrary view. That is not a contrary view. The bail was granted. I mean,
Granted, my lord. That's a, my lord, that is a case, my lord, from the same honorable judge, my lord. Taken in different view, my lord. I'll also come to that. First, your lordship will kindly speak page 170, my lord.
179.
170, my lord.
170. Okay.
Yes.
Yes.
Mr. F.C. Viswas, learned counsel for the petitioner, has harped mainly on two grounds: violation of section 36 as well as 48 of the BNS. As far as 36 of the BNS is concerned, it is provided that every police officer, while making an arrest, shall give full identification of his name. It is also provided that he should prepare a memorandum of arrest which has to be attested by at least one witness who is a member of the family of the arrestee or a respectable member of the locality, and the same should be countersigned by the arrestee. However, it is provided that under clause C of 36 BNSS, that unless the memorandum is attested by a member of his family, the police personnel is mandated to inform the arrestee that the arrestee has a right to have a relative or a friend or any other person to be informed of his arrest. As such, it is seen that in case where memorandum is not attested by the member of the arrestee's family, the arrestee has to be informed that his relative should be informed about his arrest. In the arrest memo, it is noticed that WT message is sent to the relative friend of the arrestee. It is not produced by the petitioner that a memorandum having the attestation of a witness being a member of his family was prepared as per clause B of section 36, or in the alternative, in the said arrest memo, the attestation is taken of any member of the family. And due to the said fact, clause C of section 36 of the BNSS comes into play. The submission of the learned counsel that clause B is a mandatory requirement. However, the same being with a rider as provided in clause C of the said section, the same submission does not appear to be correct. So here also this view is taken, that's in terms of 36C.
You substitute.
Yes, ma'am. The same, my lord, from the same honorable court, my lord, at page 165, my lord.
This was a different view.
Or other view, my lord, that it has to be done, my lord. If there is a violation, it will be violation of paragraphs 11 and 12. So, my lord, the lordship has seen, my lord, there are views, my lord, which do not align. with
About
each other.
three judgments,
There may
three.
be others also, but I found like
Mm.
4 or 5 in our favor,
Mm.
3 or 4 against our favor.
It has to be
Your
resolved.
Lordship will kindly see one aspect. The view, the contrary view.
Mm.
That 36C.
Mm.
Which mandates that if a family member or a friend or a relative is informed. Is correlated to section 48. So if there is compliance of section 48.
Mm.
Then 36B1 need not be there.
Mm.
Whereas, my lord, in my respectful submission, it is 36B1 which comes in first. B1 mandates that it has to be signed by, it has to be attested by a witness.
Mm.
If the witness is not a family member,
Mm.
then then the accused has a right to have his family members informed. So 48 would be a step later than 36B. And herein is a case, my lord, where there is no signature. So what was the subjective decision taken by the IO? Did he find a family member? Did he find a respectable member? Why did he not take recourse to 36B or 36C? These are other aspects which, because there is absolutely no mention of any witness. So the witness is not there. And even otherwise, it will always be B1 first, then C, both being connected by a conjunction, meaning, my lord, they both have to be separately seen and examined.
Mm.
Then 48 would come. It cannot be the other way around, my lord. A subsequent act, my lord, which can take place within 24 hours, my lord, before his remand, would somehow validate an act which is contrary to the statute, which is to be taken, which has to be
The
done
point of
earlier.
arrest.
Yes, my lord. Now, one more thing, my lord, which your lordship will examine, is all of this is coming from DK Basu, my lord.
Mhm.
So this original dicta remains comes from the Honorable Supreme Court,
Yes.
and that remains binding for everybody.
That cannot be diluted.
That cannot be diluted, my lord.
That's true.
So irrespective
so.
of the different views which have been taken by this honorable court, the source and the origin of section 36,
Mm.
the very fact that it emanates from article 21 and 22, and the fact that if there is any infraction of article 21 and 22, my lord, in that case the person becomes entitled to bail. These are all aspects, my lord, which have come down from DK Basu. So that being a judgment from the honorable apex court, my lord, it is in my respectful submission, my lord, in spite of the conflict of opinions, my lord, that judgment has to be followed. So there is one division bench judgment of this honorable high court also, my lord. Your lordship will kindly come to page 38, my lord.
Of the compilation.
Compilation. Then NIA appeal, my lord,
Okay.
and there is a concurring judgment, my lord, which your lordship will find
Written this doesn't.
at page 52. It is not just a case of a, my lord. There is a division bench judgment also, my lord.
That's it.
To an extent, some findings are also there, my lord. Your lordship will see para 3, my lord.
Para 3.
3, my lord. Page 52, my lord.
Mm.
The records reveal a solitary lapse. No, sorry. The records reveal not a solitary lapse. But
Para
para 3, my lord, page 52.
52.
52, my
The
lord.
concurring
Concurring
opinion.
opinion.
Okay.
The records reveal not a solitary lapse, but continued defects. Absence of a duly signed arrest memo in terms of section 41B. Lack of contemporaneous material suggesting denial of the accused person to sign such arrest memo. Lack of demonstrable communication of the grounds of arrest as mandated by law and explicated in Bihan Kumar. Non-compliance with section 50A CRPC. And a failure to adhere even to judicial directions requiring supply of materials to defense. Such safeguards are not ornamental. They are integral to the guarantee of personal liberty under Article 21. Their dilution transforms the process of arrest from a regulated act to an assertion of authority. Equally, the argument that no prejudice has been caused cannot be countenanced in the context of my learned brother's findings. Prejudice in the case like the present one inheres in the very denial of safeguards. It is the inability of the accused to effectively know, challenge, and respond to the grounds of his arrest at its exception. The appearance of the counsel at the time of remand and in the absence of handing over the required materials, lack of information thereof, itself is a prejudice for the inability of the accused persons to effectively know, challenge, and respond to the grounds of their arrest. To insist upon a further demonstration of prejudice is to misunderstand the nature of the right itself. It is important in this context to record that liberty cannot be conditioned upon post facto justification. Now, this is, my lord, important. Here, my lord, if this argument is to be accepted, that a 48, which is done subsequent to
Post
the
facto
arrest,
justification.
that becomes a case of post facto justification, which the division bench of this honorable court negates, my lord. So there is also a division bench judgment on this aspect. The arrest memo issue is also there. And a person, when a person has been arrested, he has been put behind bars. His liberty has been curtailed, my lord. And no further prejudice is required to be shown, my lord. The very fact that he is in custody, that is itself, my lord, enough prejudice, my lord. And just, my lord, one last finding, and I have to one last submission, my lord. Page 152, my lord.
152,
152, my lord.
Supreme Court.
Supreme Court, my lord. What happens, my lord, when there is a violation of Article 21 and 22? Your lordship will kindly come to para 8, page 153.
Yes.
Second last one, para 8. Once a court, while dealing with a bail application, finds that the fundamental rights of the accused under Articles 21 and 22 of the Constitution of India have been violated while arresting the accused or after arresting him, it is the duty of the court dealing with the bail application to release the accused on bail. The reason is that the arrest in such cases stands vitiated. It is the duty of every court to uphold the fundamental rights guaranteed under Article 21 and 22 of the Constitution. But Article 21, my lord, has broad contours, but here, my lord, when the very inception of his denial of liberty
It's clear.
get vitiated, my lord.
It's quite clear, actually. Anyway, so, this much.
My lord.
Yes. Yeah, otherwise, he has, my lord, nicely pointed out, my lord, everything.
Taken some time, but it was necessary for these things.
But
This has to be clarified, actually, and made clear, so that there's no difficulty later on. Anyway, so would you like to
I
argue
have
today?
disagreement, my lord, regarding some points, my lord, on those points I will have to.
Would you, I'm just asking, sir, will you argue today or will you argue with the reply of the fixed,
To take some time, my lord,
the fixed matters on Thursday, that day?
Thursday, yes. If I can understand, my lord, crux of his argument, my lord,
Hmm.
firstly, that, my lord, regarding, ultimately, my lord, his crux of the argument that 36B of the, my lord, DNSS, which is, my lord, already, although, my lord, compliance of 48 is there, my lord, in that, after compliance of 48 also, my lord, while 36B, your lordship has also already separate provisions, so 36B has to be complied with, need to be, my lord, must be complied in spite of, my lord, compliance of 48. And while otherwise, my lord, provision of section 48 and 36B, my lord, would have been, my lord, two different, my lord, separate section would have been not inserted in, my lord, in the BNS or other provisions, my lord. And regarding other, all other aspects, my lord, regarding that, those, my lord, guidelines of the, my lord, DK Basu, those guidelines which were source of all those guidelines is the Constitution, my lord. Ultimately, my lord, source of every law is the Constitution, and violation of any of the provisions of the Constitution, my lord. That is, my lord, no one can violate any of the provisions of the Constitution. Only one aspect I would like to point out, my lord, regarding your lordship. One question comes, your lordship may kindly for a moment. Regarding clarification, my lord. Hello, what? Initially, my lord, Article 22 of the Constitution, my lord, before, my lord, the decision of the Bihan Kumar, who clarifies that, my lord, non-furnishing of the written grounds of arrest, my lord, that arrest itself is illegal. Earlier also, my lord, Article 22 at that point of time was very clear. That, my lord, no person who is arrested shall be detained in custody without being informed as soon as, but at that point of time, without being informed is there. Later on, my lord, Bihan Kumar clarification was made that, my lord, written grounds of to be furnished to the, my lord, accused person. Regarding the present 36B, my lord, till now, although there are conflicting decisions of our High Court, my lord, regarding in case of if 48 is complied, then 36B is not at all required to be complied with. Regarding that, my lord, conflicting decision of our High Court on one division bench judgment of the, my lord, Calcutta High Court earlier I pointed out, my lord, that is also with me. And all those aspects I will point out, my lord. Today I will have to take time by showing that, my lord, provision of the Article 22. I am just pointing out to your lordship that regarding that aspect was clarified only after by the Bihan Kumar, and after that clarification, my lord, it is now mandatory that, my lord, written grounds need to be furnished to the accused person after arrest. But till now, Supreme Court has not said that violation of section 36B. There is no such decision of the Supreme Court till now that my lord, violation of section 36B arrest is illegal. Non-compliance of 47 and 48 arrest is illegal, my lord. Those regarding
Actually, true,
that
that's,
aspect, Bihan Kumpar,
that is true.
Bihan Kumar,
Uh,
Kobir
that is
Purvasar,
true, that's,
all those decisions are there, but my lord, violation of section 36B, arrest itself is illegal. There is no such.
because that issue has not been taken up by
Not
someone.
taken up,
You know,
yes.
actually, see, we can also look at it that way. We'll close it in this thing. You can, on Thursday, we'll keep this.
Thursday, my lord, I will prepare.
And secondly, because you submit, the only problem on Thursday, Fridays is that we'll have the constraint of little bit of time because of the approaching this thing. You try to complete it. You know, I have 2 days, next week also I'm
One
sitting
aspect also
in the vacation court, I'm sitting to next 2
one
days.
aspect also has to be looked into.
So after
regarding
we
that
complete the
aspect
matters on
also.
30 and 2nd
Yes.
July, then we can also conclude if necessary. But otherwise you can follow. One point, one thing I just want to say is that DK Basu says that this has to be, DK Basu says that that DK Basu does not say that not following will make the arrest illegal.
Yes, sir.
But DK Basu says that this follow from Article 21. From the Constitution, it follows. It stops at that. DK Basu holds the field.
And my lord,
Now, even if we don't go into all the other leading decisions, Pravir Prakash ka Bihan Kumar, even if we look at Subhash Sharma, you know, it
Subhash
says
Sharma,
that
I have-
anything which is any arrest procedure which is violative of Article 21, 22, will make the arrest illegal and bail has to be given. DK Basu holds the field. So in a way, by deductive reasoning, this can be said
Yes.
that this has to be followed and not following will. But Supreme Court in so many words has not said that because it has not been taken up. If somebody, you know, raises that question that where it is sin, that it does it follow, then it will be decided. Litigation is like that only, as we know.
One line of the DK Basu judgment, my lord, last time already here. It is therefore appropriate to issue the following requirements to be in all cases of arrest or detention. Illegal provisions are made in that behalf as prevented.
And they have been made.
Yes,
and they
thereafter,
have
when
been-
all these
they
legal
have been made.
provisions were made, now we will have to comply with those legal provisions.
So the best thing
In
for
pursuant to those guidelines, these legal provisions were made. And my lord, now what those legal provisions says, my lord, mandated, that will also have, we look
Yes.
at one other aspect, my lord, regarding those NDPS cases, my lord. NDPS cases are all, my lord, here also. my
so
lord,
far no distinction has been made.
Yes. my lord.
But this one determination in one of the judgments, that's because because it has been clearly said that once, see, constitution provisions are above everything else. Okay, so once the arrest is found to be violative of constitutional provision, then it will prevail over statutory bars. It follows. We have not said that. It has been said by Supreme Court in Bihan Kumar very clearly. So this will follow. It has been said in cases of NDPS or UAPA or PMLA. It will follow in everything. So the law is best when it is certain, right? So the position should be very clear so that the IOs follow it, and then they can be held accountable for not following it. If we give confusing signals, that will be they will mix up things, and there will be scope for manipulation also.
In fact, in my case, in item number 18, she is a woman, she was arrested at night, she was detained in police station, and they have shown to be arrested on the following day. Now, who will prove that I was arrested at that night, Lordship? Because from the FIR it is apparent I was arrested at night.
Mhm.
Now, if witness signature is not there, who will testify that I was arrested at night?
Mhm.
So these are the procedure of arrest, Lordship. So they
Each
have
of
to follow it.
the three documents has a standalone purpose, actually, in my humble opinion, right? So anyway, our alternative viewpoint of the coordinate another bench is also, you know, has to be due respect. As it is said, you can have any opinion in this world, but it should be backed by reason. I should give the reason. So if I have to hold that view, if my reason is acceptable to you, you may accept that view also. But doctrine of precedent, again, how will you implement? It has to be one view. This is the view of this court. This is the view of.
I will submit few points
Yes.
on it.
Well, recently, one decision I have pointed out, handed over to your lordship regarding that, my lord, in the form of drug abuse, sovereignty, and my lord, on
Yeah,
last
No, whatever it is, it has to be laid down clearly that this is not applicable. But again, said this will violate. Constitutional provisions are applicable to everyone. Everyone, they are above.
That was in the context of
Mm.
prolonged incarceration.
Mm.
Here, the very factum of the arrest is special.
I told you not that the judgment is the beginning of a journey on a stupid different direction again. But if exception is made, that's another thing that has to be justified again. But constitutional provisions, as I am repeating, it's above everyone's. Best is you it's laid down clearly and it has to be followed. And if today, as I said, 24, no, I may not blame. 24, it was emerging. But today, there's no excuse, especially for serious offenses. There's no excuse.
Otherwise, my lord, today he has nicely pointed out, my lord, everything by citing all those conflicting judgments.
It's
also
taken some time, but it's okay.
regarding the
So
provisions,
it
also,
helps.
but regarding the some of the aspect, I will reply. Wherein some disagreement is there.
Learned counsel heard Counsel S. Nawaz for and A. Ahmed, he took his full stop. So addresses his arguments on length and cites several case laws. The learned P. Bhattakur learned additional P. addresses his reply briefly, but the same remains inconclusive. This is the matter on Thursday.
Immediately upon vacation,
Let us fix it on Thursday with the matters. Then we said
My lord is giving his part of my.
part of it has to be part of course. We have 2 more days next week. If my list is short, we can take up also. Provided you don't go, you may also. I cannot.
But I've just-
I cannot blame pursue.
My lord, I've just given a small write-up, my lord, on the bullet points on my summary, my lord, I've given, my lord.
Yes, yes.
Deeply.
You can also give a few points if you want. Mr. Bhattakur, you can also give a few points. Written submission saves time, definitely. I don't know, time constraint. Let us quickly finish the other matter, at least the bails. Next.
Before started my land council, therefore the petitioner object. My submission is that filed a counter affidavit objection.
Yes, please. Can you repeat?
I have to file a object counter affidavit here.
You're for respond number 2.
Yes, Lordship. Some accommodative reason.
POCSO matter.
Yes, Oxford.
When will you file it?
Lordship, 3 to 4 days. This week, Lordship.
So we'll fix it this week or after vacation? There was a
Reopening was immediately after reopening.
Immediately after it,
Yes, sir.
and your lordship, my submission is also there, because record is available here prior to May.
Mhm.
So now 3 witnesses were.
updated record.
Yes, the updated record is necessary, so updated. Okay.
Okay. Or so and learned counsel. Mr. Goswami for respond number 2. The learned counsel for respond number 2 submits that he represents the informant and would like to file a written objection and seeks some time for the same. Full stop. The prayer is allowed. Full stop. The scan record sent on 22/5/2026 has been is available. Full stop. The learned counsel for the bail petitioner submits in this context that in the meantime, 3 witnesses have been examined. Full stop.
Total 3 witnesses were examined.
Examined.
The record by the only 2 witnesses.
2 witnesses.
In the record, only 2 witnesses.
2 witnesses. The learned trial court is accordingly requested to send a scan copy of the PW3 of the deposition of PW3
And any other.
Any
Or-
other example?
and
Examine on the.
and any other any further witness examined and deposition of any further witness recorded in the meantime. Leave the matter on. Can it be on 16, 17?
70.
17. Yes. 17.
Okay.
Yeah, please, Your Lordship. But in this case, my lord, CD was called for and notice was issued, my lord. I've checked the record, my lord. There is a my lord, office note along with my lord, status report, my lord, which shows, my lord, the notice is delivered. There is
Deliver.
a take concern, my lord. So I pay for my lord today almost 60 days. So I pay for
Here CD notice.
and CD also.
Is it a POXO matter?
POCSO matter.
POCSO for it.
So we'll appoint an amicus.
Lordship. That will-
You can suggest someone. List con like Mr. Gogoi, learned counsel for the petitioner, and E. Sharma, learned additional people. Full stop. The learned counsel for the petitioner draws attention to office note dated 19/6/2026. Full stop. As per postal consignment track report, within bracket flag it, the notice has been delivered. Full stop. Home. As none has appeared on behalf of respondent number 2, the learned counsel dot is hereby appointed as amicus. Senior advocate to nokoribo teo. D. Gogoi is coming. Dixit Gogoi. D. Gogoi.
They have confirmed my own 14 or 15 my lord, immediately reopening.
Copy may be furnished to the learned amicus,
I will furnish.
and a name may be shown in the cause list.
Okay.
List on. You want it on? Yes.
15 or 15.
No, my lord, that is 17th, my lord. 17th. CD, my lord.
Because of acha, case diary is also not received. Issue reminder. 17.
My lord. 17th.
Diplomat.
This is also a POCSO matter, my lord.
Yes.
And as per office note dated, my lord, 20 June, my lord, TCR has not been received. And service report is also awaited as response number 2.
It's
But
office.
here-
Not been
My lord, service completed, my lord. We have received the report, my lord.
service complete. So, but scan record is not.
Fine.
First. The Mr. Sharma, learned additional PP submits that service upon the respond number 2 informant is complete.
Right.
Full stop. As none has appeared on behalf of the
Response.
say respond number 2, S. Das, Surajit Das, appointed as amicus for the said party. The copy may be furnished to the learned amicus, and his name may be shown in the cause list. The TCR,
Right.
learned counsel, Mr. Das, Mr. points out that the scanned TCR is not received. It is at the stage of trial.
Yes, my lord.
Scan.
PW1 for already.
It is submitted that the case is at the stage of trial, and so far, one witness has been examined. Victim, not victim, no.
Informant, my lord.
Issue fresh requisition for the scan TCR comprising if there is charge and depositions and other relevant documents of special POCSO 15/26 within bracket arising out of Silapathar PS case number 34/26. List on, give it on 16th if possible.
My lord, in 17. my lord.
17, okay.
22.
The regular bail application, my lord. Lordship will kindly have a look at page 19, my lord. The forwarding report, my lord.
Yes.
May I read, my lord?
Forwarding report. Yes.
The type copy, my lord, with
Yeah.
reference to the subject cited above. I have the honor to report that I am producing herewith the below noted arrested person to your honorable court to keep them in judicial custody. The brief fact of the case is that on 25/5/26, the complainant, namely Tinku Bora, lodged an FIR at Dhing PS that on 22/5/26, due to defect in SBI CDM, he made two transactions from two different persons in exchange of paying cash and debiting in my SBI account. After receiving the amount, he made a transaction online on the next working day to his brother. After that transaction, his brother too made transaction, and thereafter both accounts got freeze or blocked. After confirming with the bank customer care executive, he came to know both their accounts were showing hold. They brought the both suspect to the police custody. After inspection by police officer, they came to realize they made many many unauthorized transactions from the bank accounts and showing suspicious of cyber fraud. Suspicion, my lord. Now here, my lord, the petitioner, only one petitioner, my lord, he is behind the bars, my lord, for 30 days, exactly today, my lord. And my lord, all the sections, my lord, if your lordship have a look, my lord, at page 14, my lord, page 14, my lord, the section which have been registered, my lord, 61(2), my lord, that is criminal conspiracy. 3162, my lord, that is a criminal breach of trust, my lord. 3172, my lord, receiving of stolen property. 3184, my lord, is a cheating, my lord. And my lord, so far, my lord, this IT Act is concerned, my lord, and it is identity theft, my lord. It is for 3 years, my lord. And all these cases, my lord, the punishment is below 7 years, my lord. 7 or below 7 years. My lord. So, my lord, the arresting authority, before arresting the petitioner, my lord, has not complied with the section 35(3) of the BNSS, my lord.
Then we have to see the reasons given for
Yes, my lord.
not complying. with the-
Then your lordship kindly have a look at the original forwarding report that is at page 21, my lord.
Yes,
No ground have been cited, my lord, as to why this notice was not served, my lord. And moreover, my lord, it's a 60 days, my lord, period, my lord. Already, my lord, behind the bars, my lord. for 30
It's written something, but I cannot, anyway.
Yes, my lord.
From the here, that is not legible, এই অভিযুক্ত ব্যক্তিসকলে বহু বেংক একাউণ্ট ব্যৱহাৰ কৰি ভাৰতবৰ্ষৰ বিভিন্ন স্থানৰ পৰা বিপুল পৰিমাণৰ সন্দেহজনক আৰু অনুমোদিত লেনদেন সংঘটিত কৰাৰ প্ৰাথমিক তথ্য পোৱা গৈছে। So my lord, the informant is the person, my lord, he my lord handed over case amount as per information, my lord, from the FIR, it handed over case amount to the accused person. Thereafter, these accused persons, my lord, transferred the amounts which they took, my lord, from the informant to particular some of the accounts as per the instruction of the informant. So later on, my lord, when bank account of the my lord informant was freezed, then it came to know that the informant came to know that my lord, on inquiry that probably that account of the accused person is my lord linked with some my lord some cyber offenses, and for which my lord, as because their amounts were transferred from their accounts. So my lord,
Okay.
later on during investigation, my lord, your lordship may kindly present some.
My lord, my answer was not given by the APP, my lord, whether that notice was served or not. My lord.
Notice was not given, but yes, I cannot read it actually,
My
too
lord,
small.
Yes, my lord.
Can you read it?
There should be a note from the IO, my lord, why notice was not served, my lord.
This is also another point, actually, but this may not
And
be.
but with regard to the length of detention, my lord, already 30 days, my
But
lord.
the allegations are very serious, and according to them, this kind of
lord.
financial crimes across the country.
No, my lord, the money is given to me in cash, my lord. I transferred the money to his account. How his bank account got hold, my lord? How can I know, my lord?
Sure. Anyway, so let's see.
Some type of businesses that in case of my lord, when in
Now, whether there is any note in the case diary, my lord, why notice was not served, my lord?
Could Police officers in serious cases, if they are not following these procedures, then they should be departmentally proceeded, Otherwise, the interest of society is there. Anyway, so this is more clear. This is more
Second,
clear.
I will check, Mal.
Wait,
Yeah, but in the forwarding report regarding that, nothing is there. Mal. From the case diary, I will have to find out if there is any ground. Any note of the IO is there.
In these kind of cases, it is not practicable also to give notice because they will flee or destroy evidence. But the note, at least one line should be there. It is very easy to write that.
I was taken on remand for 3 days or so.
Also. He has written some, but the thing is that actual sentence should also be written. He has indicated that, but he has why he was arrested. But that sentence, what is the harm in writing? Because that was not practicable to give notice because of this. So,
Specifically, my lord, why 35?
he should be satisfied. They should have to be trained in these things anyway. At least stays. What are the materials of investigation?
Material investigation is going on because those are some digital evidence. The mobile phones, my lord, is the accused person, my lord. And
30 days, right?
30 days, half of the
mobile
murder.
phone, it seems that on the
My lord,
various places, my lord.
petitioner to keep it. কাম তো কি করে দিই?
One is of cyber offenses were transferred to those accounts. Yeah.
Length of detention also, lordship.
E1 is 460 days.
It was a catch. E1,
Just a minute. Yes, right. Heard Mr. Anjay, Dr. Learned Counsel for the petitioner. And P. Botagor learned additional papers. Invoking 483 BNSS, the petitioners are seeking the one petitioner, right?
one petition.
Seeking bail in connection with Dhing PS case number 132 of 26 under so section. He was arrested on 25, he was arrested on 24, 25 5 2026. And also stated to have been in police remand from 25 5 2026 to 35 2026. The case was lodged based on FIR. The gist of the allegations in the FIR is that due to defect in SBI cash deposit machine, the informant made 2 transactions from 2 different persons in exchange of paying cash. And after receiving the amount, he made an online transaction on the next working day to his brother. Whereafter his brother also made a transaction, and thereafter both the accounts got frozen. So later, upon informing the bank, the informant came to know that the account of the accounts of his and that of his brother were showing as hold. subsequently, the present petitioner and another co-accused were arrested. Mr. Dutta Learned Counsel submits that the offences being punishable up to 7 years, no notice was given under section 35 of the BNSS. Full stop. It is also submitted that they have been custodially examined and have been in custody since 30 days. Full stop. Vis-a-vis the applicable statutory period of 60 days. Full stop. On the other hand, the learned additional PP opposing the bill submits that there were sufficient grounds for arresting the accused persons. And investigation is also indicated involvement in such of financial in illegal financial transactions constituting cyber crimes. Full stop. I peruse the relevant portions of the case there. It is revealed from the investigation per se that the accused persons in collusion with others have been engaging in several illegal financial activities targeting bank accounts of customers, and such activities have proceeded beyond the state of Assam, and that the account of the informant and his brother were frozen on at the initiative of the police from other state, including Maharashtra. Full stop. Maharashtra and Bihar. Full stop. Considering the nature of the materials and the ongoing investigation, the bail petition stands rejected at this stage. Return back the case then. Okay.
I'm okay.
Yes. My lord, this is a regular bail application, my lord. Where the petitioner was arrested on my lord 1/5/2026 and forwarded on my lord 2/5/2026, and as on date, my lord, she is around 53 days in custody. So the offense is my lord, intermediate quantity is a contraband of ganja, my lord. The small quantity is my lord 5 kg, my lord, and alleged recovered my lord ganja is 5.16 2 kg, my lord. So my lord, the petitioner before your lordship, my lord, she is a girl, my lord, 21 years age, my lord, and already in 53 days in custody, my lord.
Why she was alleged to be peddling or consuming?
Earlier also, he is involved in committing same
My lord,
offense, same type of.
Page
offense.
17, my lord, the FIR.
Again, earlier also.
My lord, my lord, the earlier case is that, my lord, she was in a rented accommodation with her mother, my lord. Her mother was arrested and on some recovering of some ganja. So, my lord, immediately she was also arrested, my lord. But in the present case, my lord, she was apprehended in a different place of location, my lord, and the seizure has been made in the different place of location, my lord.
Sure.
And she was page 17, my lord.
Page 70.
17 start from FIR, my lord.
Okay. Just to inform them.
My lord, here, para number 3, my lord.
Para number 3.
Para
Just,
3, my
just a minute. I'm reading from the beginning. Augustus, sorry. GD entry was made. Team members. Upon reaching the Notun, yeah. Would you want to read? Yes.
Well.
Upon reaching the Notun Bazar area,
My lord.
Augustus Ariali, we saw the suspected team members were. And the ladies on a police train. Inside of 1+3. And someone managed to after she was my bomb.
Yeah, my lord, she is apprehended at 1 PM, my lord. And at near the Basista Base Hospital, my lord.
Mhm.
And a recovery was made in the Lalmati area near Sid Mandir. It takes, my lord, 8 minutes to come up to that place, my lord. And the but seizure has been made at 10 PM, my lord, after 1 hour, my lord. My lord will find the time of seizure at page number 29, my lord. Serial number 2, my lord, date and time of seizure, 1/5/2026 at 2:10 p.m. And place of seizure, Lalmati near Shiv Mandir, opposite BJP State Office, my lord. So the place of apprehend and place of seizure is different, my lord.
Because
And
allegation.
already, my lord, the petitioner before a lordship, my lord, he is in 53 days in custody, my lord.
Anyway, so,
I will point out from the statement of witnesses why place of seizure is different, my lord.
yes, she is alleged to have thrown the bag,
Yes, thrown the bag. Thereafter, my lord,
but it would be nearby. in that
yes.
case.
police.
According to you, it's not nearby,
Right.
it's different.
It's different, my lord.
No, it will be nearby because
Yes.
it's thrown.
Yes.
But if it is very much far away, then that contradicts with that story. Anyway, please read.
পুলিচে ছোৱালীজনীয়ে এটা ডাঙৰ পলিথিনৰ টোপোলা আৰু এটা সৰু টোপোলা কাষৰ নদীখনত পেলাই দি পলাবলৈ চেষ্টা কৰে। পুলিচে লগত লৈ অহা মহিলা পুলিচৰ সহায়ত ছোৱালীজনীক তাত ধৰে আৰু নদীত পেলাই দিয়া টোপোলা দুটা বিচাৰি নামি যায়। পুলিচে তাত এটা টোপোলা পাই যদি এটা টোপোলা নদীত ভাহি যায়, পুলিচে লগে লগে ছোৱালীজনীক গাড়ীত পাই সেই টোপোলাটোৰ লগত লৈ ভাহি গৈ থকা টোপোলাটোৰ পিছে পিছে গৈ থাকে। পুলিচে ভাহি যোৱা টোপোলাটো অফিচৰ সন্মুখৰ নদীটো উদ্ধাৰ কৰে। So, my lord,
That is why.
yes, that is-
That explains probably. Anyway, Caesar
Earlier
witness,
case, my lord,
can I see the case diary?
CISCO PS case number 526/26 under section 20B2 B29 of the earlier case, my lord, registered agents.
She was arrested with her mother in the earlier case.
That is regarding that, my lord, there is
Okay.
nothing in the CD, only case number. my lord.
My lord, here small quantity 5 kg, my lord. And Alice recovered contraband 5.1 kg, my lord.
It is
5.16 plus 1.085 mil.
ganja is 20 kg and lower is
5 kg, my
slightly
lord.
forgotten, 5 years. 5 kg or?
Small quantity,
Here more than 5 kg, mil.
5.1.
Above 6 kg.
I have that chart, no? That central government notification, it indicates the quantities
Yes.
notification. It's not 1 kg, no? Small quantity, 5 kg.
Here 6 kg.
They must have, they check that while giving the section usually, but still we should cross check. The witness.
Small quantity, 1 kg. 1 kg.
Oh, 1 kg, yes. That's why. 5 kg is intermediate quantity. Where is the Caesar witness? I'm not finding it.
Is a witness.
Heard, heard some learned counsel for the petitioner. Invoking 483 BNSS, the petitioner and so is seeking regular bail in connection with Bokhisto PS case number 138 of 26 under of the NDPS Act. The petitioner was arrested on 1/5/2026 and stated to be first remanded on 2/5/2026. full stop. The allegation in the FIR dated 1/5/26 lodged by SI Ankur Burman was that upon a secret information about peddling of illegal drugs, a police team proceeded to the area and found the petitioner coming on a two-wheeler, and upon seeing the police, she threw away bags and tried to flee, whereupon she was apprehended along with one bag. Uh, and then the other bag fell in the nearby river stream. Full stop. Learned counsel submits that she has already spent 53 days in custody, and there is the place where she was arrested is different from the place where seizure was made of the bag. The case diary is received. The learned additional PP submits that one of the bags thrown by the petitioner, accused petitioner, was recovered from the place of occurrence, and another fell on the river, and the police seized the same at a subsequent point alongside the river. Full stop. It is submitted by the learned additional PP that the petitioner was also prosecuted in another NDPS case, being what is the other case?
526. What is the PS case number 526?
526 of
26.
2026. Full stop.
Yes, 526 oblique 20. Under section 20B2, capital B 29. Page 23.
The informant has supported the allegations in the FIR. The investigation lends support to the allegations. Full stop. The seizure witnesses have also supported the allegations about the seizure of the contraband. Full stop. And the nature of the incident indicated in the FIR. Investigation is in progress. At this stage, the bail petition stands rejected. Return the case diary. Full stop. Also peruse the bail objection report likhi dibo kahin. Bail objection filed by the IO. Let the investigation get complete.
Hearing 24.
Return the case diary. Abin.
Bail period. It's a pre-arrest bail, my lord.
Okay.
I was protected, my lord, in this case, but
Sorry.
Search sheet submitted, my lord, in this case. Interim is there.
Probably yeah, or page 2 to 4. Petitioner was granted interim bail by order dated 16/12/2025. The case diary was called for. Full stop. However, the learned additional PP submits that in the meantime, charge sheet has been submitted upon completion of investigation. In view of the completion of investigation, I do not deem it necessary to cancel the interim bail. Accordingly, the interim bail by so is hereby made absolute, subject to the condition that available for trial shall not hamper or tamper with evidence.
I'm obliged. Keep your.
Search sheet number 296 oblique 26, dated 26/4/26.
25.
May I please, your lordship. Pre-arrest bail application, lordship. Petitioner was protected, lordship. Thereafter, he had appeared, lordship.
He has appeared. No?
The CD received, my lord. So perhaps respond number 2 also appeared in the last occasion.
Yeah, Mr. D made he has appeared.
My lord. Not respondent number 2, lordship. Actually, the petitioner.
No, you are D made.
Yes.
I'm sorry.
The earlier the petitioner was represented by different set of counsel.
Okay.
Then they have
You are appearing for the petitioner.
petitioner itself.
Oh, it was
Then they have-
wrong by mistake in writing. And
Yes.
now who's appearing for respond number 2?
The
You
respondent
don't
number 2
know.
has.
But someone has appeared.
Yes.
Someone has
No,
appeared.
no. For respondent number 2, no one has appeared.
No one has appeared.
There is an office note, my lord. It's for office. I
No,
was-
no, wakalatnama on behalf of the
On
petition.
behalf of-
Newly.
Fine.
So that was by mistake written as
fine.
respond number 2. What about service? It is complete.
No,
Service
POCSO
on,
not here. No, for no POCSO.
oh, it's not a POC for this. Then why respond number 2? Is it necessary?
Not necessarily, but perhaps he maybe in the last order I have seen, my lord.
Mhm.
Perhaps
It
it
was
was taken
supposed to
by
be-
mistake.
Ah, yeah, by mistake. By mistake. Yes. Oh, there is no respond number.
No response.
That's no problem. I didn't understand. Diary?
There is my lord. Is there is my lord? After entering his appearance statement recorded. My lord, he is the police official, my lord.
Hmm.
He is the police officer, my lord. Yes,
Achha.
my lord.
What happened actually?
What happened, my lord? In this case, my lord, he has investigated the case of road accident, my lord.
Uh-huh.
In that case, my lord, when initially he made GD entry and on that basis he found that, my lord, the accused has, my lord, hit in a electric pole and thereafter succumbed.
Oh.
Thereafter, my lord, from the complainant side, filed one, my lord, complaint and said. that
Insurance
one-
company.
Insurance company, and thereafter one wagoner involved in
Yes,
this case, my lord.
these
That's
things
the
are
issue,
done
my lord.
sometimes.
My lord.
The statements of the PWs are also there, Lordship. Lordship may find it on,
Thereafter, some person
page
came
for
and said
90
that they are the eyewitness, my lord, and wagoner has hit the, my lord.
Anyway, we'll
My lord.
cancel.
Right.
Let it be. These things are, as a police officer, when they
My lord.
as per the version of the eyewitness, this complaint was registered thereafter charge-sheeted. Only grievance that came along with this complaint that the accused who was driving the Wagoner and the complainant had settled the matter in JMFC court. That part, the investigating officer is
He may
no way
be-
connected or he is no way concerned of it.
learned counsel for the petitioner and this Verma. 482, Dhemaji PS 45 of 2026. Full stop. By the order dated so and so, the petitioner was granted interim bail with conditions. It is submitted 11/3/2025. Learned Mr. Mehdi, learned counsel submits that pursuant thereof, the petitioner, who is a SI of police, has
Yes, sir.
appeared before the
IO
IO of this case, and his statement has been recorded. Full stop.
earlier,
Hmm.
the backdrop of the case
The
in which this case was
the
registered.
learned additional PP has confirmed that he has appeared. He has appeared and his statement has been recorded. In view of the aforesaid developments, I do not deem it necessary to cancel the interim bail granted. Accordingly, the same is made absolute. Number one, conditions, cooperate with remaining investigations, shall not hamper or temporary evidence. Full stop.
Fine, deeply obliged.
Disposed of. Return the case there.
This is.
The pre-arrest bail application
Mhm.
on a basis of a 67 notice.
Oh.
Both of us friends can be, they had a discussion that did it come on 14th for final disposal. So some time will be taken, here,
Take-
because they have filed objections saying that the accused has stated my name and my phone number is with them.
Mm.
So, and they have issued me a 67 notice.
Oh, after vacation, on 14th,
Today, the time constant is.
Roy Chaudhary, learned senior counsel. And RKD Chaudhary, learned senior counsel and deputy SGI, who's representing the NCB. Full stop. The learned Mr. Roy Chaudhary, learned counsel for the petitioner that the matter might necessitate hearing at some length and praise for posting the same on 14th after the summer break, summer stuff. The non-standing council NCB has no objection. Full stop. List on case diary is received. This is record.
Offense report has been
Oh,
received.
The offense report is available and the prosecuting agency has also filed the objection,
Yes.
written objection. Full stop.
Well,
List on 14/5.
Another preamble, item number 7, some urgency is there. Can it be fixed on 25th?
Just a minute. It could be possible, not 20. Item now 7.
Can it be fixed on 25th? Today it will not be possible.
25th. Okay, 25th or 26th?
So, well, 25th.
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 Fixed on 25th.
27, 28.
Yes, with your option. Question, item number 27 and 28 are wrongly tagged my lord.
What's, they are not
They are
same,
different case.
not
Different
different.
case, my lord.
We'll untake them.
Here, up-to-date CD was called for, my lord, not received, my lord. today.
I am on interim, my lord, at item number 27.
Okay, first let us take a call on this. Okay, full stop. It is submitted that the matter has been incorrectly tagged with BA 252 of 2026, and that these are different. These matters may be listed separately from now onwards. Full stop. The petitioner was granted interim bail on 26/5/2026. Full stop. He must have appeared or something. The case diary, updated case diary was called for,
For not received.
but not received. Full stop. The interim bail stands, issue requisition for the same. The interim bail stands extended till the next date of listing. List on, you can give it 21/7.
29.
28 was it? That would be polite.
The second
To
application, my lord.
Bora, it is submitted that this case is wrongly tagged with AB 782 of 26. And that these are different. These two bail petitions may be untagged, listed separately. Full stop.
I said it was.
This is the second application, my lord.
Scan copy.
Scan copy, my lord. That has been received, my lord.
My lord, in the cause list, it was not shown, my lord, here. Yeah, but I have verified, my lord, it was received in the month of February,
Scan copy.
my lord. But in the cause list, it was also not shown. And Lordship may call for updated status report, my lord, after vacation immediately, my. Scan copy received.
You are appearing for the informant, POXO case, right?
Right.
Mr. Bora and Mr. Learned Counsel appearing for respond number 2/informant. It is submitted by Mr. Sharma Learned additional PP that though scan TCR is available, but
The positions are not there, my
No,
lord.
no, it not shown in the cause list.
okay,
But,
okay.
my lord. And thereafter in the record, it was sent in the month of February. my. And it,
On 16/5/20 also, no, sorry, 25 order. It was sent it was sent from the Learned Trial Court on 13/2/2026 first.
my lord.
The Learned Trial Court is requested to send the scan TCR after 13/2/2026, including copies of deposition
Deposition.
statement. Full stop. Anything else?
Of
You have
the-
not filed any written objection, right? Nothing?
I have filed.
You have filed. The informant side has filed a written objection. We'll take it up immediately.
my-
When do
after
you, when do you suggest?
28th, my lord, after vacation.
20 or
20.
20? Monday, okay,
Obligation.
these had.
29.
Yes,
I please, Your Honor. Mr. Vedalam is on legs in court number 2. Kindly give us a date before the vacation.
okay, just a minute.
You will take in between time.
Just a minute. You are for the
Put it as per number.
respond number 2, Ms. Nazneen. She's seeking time for this thing. So today, though, it will not be possible. So her senior is on legs.
Her siblings.
Her senior is on legs. So when should we, another day, we'll fix it? After the vacation, before the vacation. Your good name, please.
Yasmin.
Learned Counsel for 6 permits that leading counsel is preoccupied in another court. Full stop. Your Ms. Nazneen appears for respond number 2. The scan record is available. Full stop. Let us fix it on 26th.
My lord.
26. On Friday.
Please, Your Lordship.
30.
My lord, in item 30, my lord, I have gone through the record, my lord. Here, my lord, wrong TCR received, my lord.
Wrong TCR.
My lord, here, it should be, my lord, Mankasar, my lord, Mankasar 08 of 26. But in the later part of the Malar scan copy, it was found Malar, Mankasar 8/26. It should be South Salmara Malar. Proximal kindly should have flag mark. Thereafter it will be seen Malar. FIR is there.
Eight of 26, no? Mankasar PS, 8/26.
It should be Malar South Salmara.
South Salmara.
Yes, I am seeking bill, Lordship, the affair and the other materials. Whether clearly or not, I am.
From the FIR, that is correct Malar. Thereafter later part Malar. Later part is it is Mankasar.
Recently, sir, that's submitted.
You are appearing for the informant?
Sections are also defined in the different case mail.
Oh, sure. We'll have to call for the Mr. Ahmed.
It is a case, two ladies before a lordship, they are the mother and sister of the prime accused.
Miss Mother and sister of the?
Prime accused number one.
I see.
And he is a juvenile, he has already been granted bail.
Yes, sir.
And there is no specific allegation in the
Order.
affair. Kindly see page 9. They may be lordship allowed since the charge sheet has already been laid.
Charge sheet has been submitted already?
Yes, that is what TCR was called for.
Submitted
That is-
Malar.
That
And
is why TCR was called.
return section 13 of the prohibition of child marriage was also added by
Mhm.
marriage against murder.
Oh, this,
And sections are defined by I have verified by the record.
but police case is same.
No, my lord, it is Mankasar and South Salmara. They have paid for bail, my lord, in South Salmara, my lord.
Hmm.
But record reveals, my lord, in the later part, my lord, it was Mankasar, my lord. Mankasar AW.
But the headings and all, it's South Salmara only. Headings, can you have,
Yeah.
please have a look. I may be wrong. Let's have a look.
I may be-
Mr. Is it, no, I think we must have
And
seen it.
witnesses are different, my lord,
Hmm.
victims are different.
Full stop. The aged Ahmed Learned Council. What do you have to submit? On behalf of the informant? Huh?
Section 6 and 7 is there, madam.
But against their sister and mother. So
Yes.
that is also there. The main accused is a juvenile. He himself is a minor. Backwardness, social backwardness. 482 VNSS. Full stop. Seeking bail in connection with South Salmara PS case number 8 of 2026. Under so and so section. Full stop.
Well, FIR is quite defined, this, the later part.
Oh,
Witnesses are different, my lord, victims are different.
Also, for a practical purpose, lordship, otherwise the trial will, lordship will delay, lordship. If these cases remain pending, lordship.
so what should we do? Get the,
Well, call for the, my lord, original scan copy, my lord. From
what do you say?
case number South Salmara PS.
It is submitted by the learned additional PP, full stop, that though the scan TCR was called for, but the incorrect case record has been inadvertently come from the learned trial court.
From
So-
the South Salmara, it is from South Salmara, my lord.
Uh,
No,
it-
my lord, it is from Mankasar, it received, my lord, Mankasar, AWKBC.
Mhm.
Mankasar, it should be, my lord, South Salmara.
Call for the scan TCR of, do you have the case number, special case
Fine.
number? It is also submitted by the learned counsel for the petitioner and confirmed by the learned additional PP that in the meantime, investigation is completed and charge sheet has been submitted. Full stop. Mr. Ahmed submits that the petitioners are the mother and sister of the main accused who's stated to be a CICL undergoing proceedings before the JJB, learned JJB. Full stop. their নামটো দিলো, learned counsel for the informant who submits that the provisions of section 6/17 are also available, full stop. Now we have to see this, the issue requisition for the scan TCR of, now you help me with.
My lord,
Main case number you don't have,
my lord.
don't have, no, main case number.
We have
PS
the
case is this,
number, my lord.
from South Salmara, PS case number 8 of 2026, from the court of that we have to- special just South Salmara at Mankasar. Full stop. Now further, considering the fact that the present petitioners are stated to be the mother and sister of the main accused, and the investigation is also complete. Therefore, in the meantime, in the interim, in the event of the arrest, 30,000 with one security, to the satisfaction of the concerned learned court, arresting authority, and subject to the condition that they have been charged sheeted also.
Yes.
Subject to the conditions that they shall be available for trial and shall not hamper or tamper with evidence, shall not intimidate, harass or the informant / victim side in any manner. Which is fixed on. After the application, you will
Fine.
give it date. Interim also granted, so
Fine.
not a problem.
23rd, my lord. 23rd, my lord.
23rd.
Sorry,
When-
I'm sorry for doubling.
Yes,
Your lordship.
I'll finish the remaining bails
Yes,
actually.
your lordship is rising at
Yes,
1 o'clock.
yes.
1 o'clock. your
Actually, I'm
lordship is not
taking
taking-
half day leave because of
No, only one
issues of my
request,
father.
One request, my lord. There is an item admission, in admission column, item number 8, my lord.
Item 8.
8.
Yes, yes,
Sorry,
yes.
item
8,
8, right?
Eight,
Item
eight.
8. So, my lord, if it is not inconvenient to your lordship, because my learned friend has come from Mumbai also. So if it is not, can it be fixed somewhere in the month of August, my lord? 11th of August? Yes, indeed.
You're for the respond,
For the petition.
your petitioner, you're for the respond,
No, we are.
We
No, no,
petition, my learned.
you're for the respondent. Yeah, okay, no problem, as you,
Then
mutually you're agreeing to fix it in the month of August,
11th August
Okay.
is Tuesday, my lord.
Tuesday. Learn senior counsel submits.
Readings complete, my lord.
Your good name, please?
Lordship, I'm M. Das, appearing on behalf of SK Maybe.
Okay. Learned counsel submits that the matter may be fixed on 11th August. And learned counsel for the respondent, and thus submits that the respondent side is agreeable to the same, fixed on 11/8.
My lord, only one humble request. My lord,
Interim,
pleading, yes, interim will continue.
interim,
Pleadings are complete, my lord, that your lordship, and it can be disposed of at admission stage itself, my lord.
pleadings are stated to be complete. And the learned senior counsel submits that perhaps it may be possible to dispose of the matter at the stage of admission hearing only, full stop.
Yes.
So the interim order by so and so stands extended till the next date of listing. Okay. Interim orders will be all extended.
Yes. And
Other matters also. No problem.
Deeply obliged.
I'll complete the ABs, don't worry.
May I please, Lordship? May I please, Lordship? Lordship, item 36, civil matter, which is order, Lordship.
Let me complete the AB. Okay, I'll complete the AB. They can make a mention. I'll complete the AB. Only 4 left.
The father-in-law of the informant is before your lordship seeking pre-arrest bail.
Father-in-law of the informant.
Informant, informant.
Family.
Lordship, the allegation, the level against me is that, lordship, her husband, lordship tortured her. When it was informed me, I want to resolve it, seeking sexual favor from her. And next cause of action is at page 11, lower portion, lordship. In the morning of 2/2/2026.
Page.
Page 11, lordship. Last para, in the morning. You got it? In the morning, 2/2/26, I went to the place of the accused persons as I was in need of a book, namely Ullah, and called my husband over phone. I didn't able to get any response from my husband's side. I entered into the house for bringing the book myself. Immediately after my arrival, my father-in-law dragged me inside and tried to rape me by tearing my clothes. In the meantime, my husband and mother-in-law appeared in the room. When I told that I would inform the incident to the police, my mother-in-law gave me my mouth so that I could not shout, and my husband tried to ablaze me by pouring petrol over my body. But I somehow managed to escape from their grip. These are the allegations, and so far as Caesar, FIR was lodged, lordship, more than after 24 hours, lordship. Because the incident was occurred on 2/2/26 in the morning. FIR was lodged on 3/2/26 at 5:45 PM. lordship.
Only one day, one day.
One day, but one
The allegations
kilometer
are
distance.
disturbing anyway.
3 kilometer distance. from
Subsequent,
the- And
because-
so far as Caesar is concerned, the allegation is only her robes were seized, lordship. No type of petrol, nothing, no jerkin, nothing has been seized. And already the accused, her husband, in fact, the son of the present petitioner, has been granted bail, lordship, by the court.
Main allegation is against father-in-law.
My lord, here, my lord, I have received
You are
case-
for the informant.
case there, my lord, here, page 19, my lord, rejection order, earlier rejection order, lordship. There is the second application, my lord, page
Yes.
1911, at page 20, my lord.
1/4. Investigation, how much has it progressed?
My lord, investigation is going on, my lord, not completed, my lord. My lord, it is submitted by referring the statement of the victim recorded before the magistrate that she was supported the serious allegation made by her against her father-in-law petitioner for the said investigation is in progress, my lord. In the implementing material in Mars, I am of the consider opinion petitioner may not be reserved and received. It was rejected, my lord.
At that
Yeah.
stage, lordship, that language was used.
Lordship, may
That's
kindly
okay.
peruse the 183 statement once again, my lord.
You can submit your,
Fine.
make your submission.
Society never expect such type of behavior from a father-in-law, my lord. And in our 183 statement, my lord.
Yes, madam, you can say.
These are section 75 and 76 and 101 BL is also. Except of, yeah, then lordship, except the lordship.
No,
That message to the society lordship.
And
you're
one-
opposing the bill.
my lord, here, one important thing is that, my lord, one important thing is that, my lord, there is no new guns, my lord. After the rejection, my lord, there is no new guns, no new guns they have placed before the honorable court, my lord. And although it is said that, my lord, there is no any, my lord, seizure, but from the, my lord, I will not, it is that,
No,
my
there
lord,
is all once.
kerosene tell,
Only seizure of torn clothes.
my lord. From the
Don't
plot,
There
it
is-
reveals that, my lord,
One
gave
One-
positive
No
test-
kerosene.
gave positive test for kerosene, my lord.
Mm.
Just found kerosene, my lord, in her clothes, my lord.
she has stated in the FI it is petrol. lordship.
Whatever, maybe it is there in the,
Anyway, so Mr.
And lordship, one thing lordship consider whether in the morning, in presence of when all the members of the house is available, son, if that is husband of the victim, her mother-in-law, whether this kind of whether it is probable, lordship.
Yes, kindly see, that is a relevant point, yes. Kindly see because they are also co-accused. The statement of co-accused only.
my lord. Okay, kindly please, one issue. And my lord,
So otherwise it is highly improbable. lord.
Even this. And other witnesses, they have found she is crying and going to the place of school, my lord. With a tearing cloth, my lord.
Somehow she said that.
It may have some scuffling, but so far as allegation of lordship, outraging modesty, attempt to rape, those lordship,
No.
attempt to rape by the father-in-law.
Mr. Dotto, Land Council, B. Sharma, and Madam, your name? P. Borpujari, Land Council, for the information. The subsequent bail petition according as an earlier bail petition, reject 1426 AB 564 of 26. The case diary was called for again and received. Land Council for the petitioner submits that in the meantime, investigation might have progressed and that progress, semicolon, that comma, the FIR was lost with a day's delay, semicolon, that comma. Except some torn clothes, no other materials were seized by the IO, thereby throwing some doubts on the nature of the incident. Full stop. The learned additional PP submits that there are no subsequent grounds. Full stop. It is submitted by the prosecution that there are statements of witnesses which have stated about seeing the informant running away from the house in crying state. Full stop. Upon perusing the case diary, I find force in the said contention from the statements of two witnesses recorded before learned JMFC. Full stop. The learned Borpujari, learned counsel for the informant, poses the bail and submits that the nature of the alleged offense is not acceptable in society. Upon perusing the materials and considering the matter, unable to find sufficient new grounds, as investigation is still in progress, the bail petition stands rejected at this stage. Return case there. Next. Same, your matter only. Yes.
Item 8 was mentioned by a senior because he does, this is a program in the 11 and 10 and I'll be out of station.
I will change the date. Kindly discuss with the senior counsel and inform.
I
In this case, yes, leave is called for. 32.
Yes.
Madam, here CD not received, madam. From Dibrugarh to CD not received.
It is second, third time perhaps.
Kindly get the CD. SC/ST Act, it's section 18 has abolished anticipatory bail, but the small window is available.
Only
18 or 18A, I think, something of the sort, 18A. But if there are no prima facie materials, then you can.
Materials is not.
We can take a chance before, you want it before vacation?
That's it.
Before vacation?
no, madam. From Dibrugarh, madam. Just reopening, madam.
Okay.
Yes, there is call for is not received, full stop. Issue reminder for the same on 13,
My lord.
day of reopening, 13.
13.
Obliged.
33. 43. My lord, in item 33, we have not received case diary, my lord. They are interim, my lord.
No problem. It's not, Mr. Bora, G. Bora. Don't write anything. None appears, none again. The case diary is not received. Full stop. The petitioners were granted interim bail on 27/5/2026. Full stop. Issue reminder for the case diary, interim bail stands by so and so stands extended in the next date of listing.
16th, my lord.
List on.
16th, my lord.
Give it a little later also. If interim is there. Give it on 22.
My lord. 34. 35.
May please, Lord. The regular bail application wrongly listed in this column.
Oh, here CD not received, my lord.
46 days in custody, intermediate quantity of heroin.
Okay.
Is there?
We will try, my lord, last day, my lord.
If you want, you can fix it. Okay, after vacation. You want it before vacation?
It will be then.
Fix it, no problem. SAD is not received, full stop. Issue reminder for the same. List on 26. One,
Right,
okay, take a chance. Okay, this, you can kindly take the dates, the others. For for my own difficulty, I'm having to, DD problem, yeah. Interim, don't worry about interim. Get a look, DD.